And it's not gonna, no video ever muted, right?
No.
Good morning, everyone. This is Peter Davis.
Good
Is
morning.
Ms. Irwin on the line? I'm not seeing her in the waiting room.
We're together. Lori, the appellant and I are together.
Very good. Perfect.
Good morning.
And Attorney Makovic, who is joining you as your assistant today?
Who is joining me? It might be, let me just double check. Sorry, these cases run together a little bit.
Understood.
It'll be Danielle.
All right,
Danielle
Danielle
Carlson.
Carlson.
Yeah.
All right. Very good.
And Laura Herman, who's in DHS's Office of Legal Counsel. She will be at some point later in the hearing, she will be attending.
All right. Very good. And attending as an observer or?
As an observer, yes.
All right. Um, Ms. Irwin, do you have any objection to Ms. Herman joining us now as an observer?
Yes, I do.
All right. And what's the basis for your objection?
You were very clear, in your, process of how the hearing was gonna be held that, only myself, the appellant, Attorney Makovich, and his assistant were going to be, present.
I did say that. Attorney Makovic, you got any thoughts in that regard?
Well, it's an open hearing, and she's not going to be a she's not going to be a party or a witness.
All right. So I guess Ms. Irwin, it is the appellant's call as to whether it's an open meeting or not. If it were public, obviously anybody could be here. If you want to keep it closed, then I guess based on my email yesterday, I won't admit Ms. Herman unless you at some point agree otherwise. What are your thoughts?
Well, actually, if Ms. Herman is going to be attending the hearing, then we would like it also opened to Deb Keither.
And is that person going to be a witness?
No.
All right. Any thoughts about that, Attorney Makovic?
I mean, it's an open hearing, but just for my information, who's Deb Keither?
Deb is a thought partner and in preparing for this hearing and has been assisting the appellant and I in putting together our exhibits and all of the components that we're going to present today.
Oh, I should have been more clear. Is she affiliated with, is she part of any organization?
No.
So she's Deb Keither, free agent, independent actor. She's not, working for an agency or a law firm or anything.
Correct.
Okay. I mean, it's like I said, it's an open hearing.
Right. So if in effect, Ms. Irwin, you're agreeing it's a public proceeding, if you will, quote unquote, I'm happy
Yes.
to admit Ms. Keither and Laura Herman as well.
Yes.
If we talked about our preferences in terms of showing ourselves on camera or not?
We do, the appellant does request that it be video recorded.
All right. Well, it's not going to be video recorded, right? Only the audio is recorded. So the video, the visual piece is just like in real world hearing. Everybody can see each other, but it's never recorded, if you will. So just to make that clear, it's not recorded. It's just a choice that you, the appellant, have on whether you want people on the screen, which would be everybody all the time, or you don't. And by, I should say, everybody all the time, meaning the witnesses as they're testifying would be on the screen. You'd be on the screen. Attorney Makovic could be on the screen. I'd be on the screen.
Yes, we would prefer that.
All right. Very good. So they're going to need to turn on your camera then.
Okay, you want to turn on?
Okay.
And that should work. All right. Not sure why I'm not showing up.
Is your Examiner Davis, if you have a state issued laptop, on the top where the camera is there like a little slider? I will
Uh,
sometimes slide that thing over and it'll cover up my camera.
Got it. Let's see. Select the camera.
Just because there's a physical thing. Like if you look at my screen right now, I'm reaching to where it is, and there's a little like thing that
Got
you
it.
can see sliding over. I'm not sure if that's, like I said, I will sometimes cover that thing
You
up.
know, I appreciate that. It's a new laptop for me. That's my only pathetic excuse. The video claims that it's on. Um, I guess I'll ask the parties if I can't figure this out, is there any objection to me remaining unseen?
We would be fine with that.
Sure.
Yeah, I have no objection to that.
All right, very good. Appreciate that. Let me admit Ms. Keither and Ms. Herman.
Okay.
All right. So we're being recorded. Are we ready to formally get underway?
Yes.
Attorney
I
Makovic,
believe,
ready to go?
I believe so. Yes.
All right, very good. So this is a formal civil service hearing as to the discharge of Ms. Schultz. The commission is appearing by Commissioner Peter Davis. As I understand it, Attorney Makovic's representing the state. Ms. Irwin is representing Ms. Schultz. And I apologize for misspelling your name, Ms. Schultz, in some emails that I've sent.
Okay.
As an opening comment, I'll note, as my colleagues do in these hearings, that whatever decision is issued in this matter will appear on the WRC website, will be Google searchable. If there are medical issues or privacy issues that we should consider in terms of what will ultimately appear on the website, the party should let me know about that as soon as possible. Anybody have such an issue off the top?
Any medical issues?
No.
No.
All right, very good. All right, with that said, I will turn it over to Attorney Makovic, and if you wish to make opening remarks, you're welcome to do so.
Yes, thank you. Good morning, Ms. Schultz. Good morning, Ms. Irwin. Good morning, Examiner Davis and all present. I'm David Makovic. I'm the attorney representing the Department of Health Services today. What we are going to show is that the Department of Health Services had just cause to discharge Lori Schultz from her employment with the department. The factual basis that we're going to show today is that Ms. Schultz had a fourth tardy in her 2026 calendar year. And though tardy is defined as either calling in late or appearing late on the date in question. On the date in question, Ms. Schultz appeared at 6:14 for a 6 a.m. shift. And then she was investigated. She was interviewed. She was ultimately discharged for this. The reason for that is that she was already at a 5-day discipline level following the state of Wisconsin's progressive discipline scheme. She, in fact, had a repeat 5-day for attendance issues. So dating back from May of 2025, Ms. Schultz has been disciplined 5 times for attendance, 5 times for attendance issues, and the attendance issues here have primarily been there have been significant issues with tardiness. Simply put, Ms. Schultz Put, Ms. Schultz has been unable to show up for work on time. And she has throughout this process, she has been informed repeatedly of the requirements, and it has been communicated to her that it is expected as a PCTA, psychiatric care technician advanced, at the Wisconsin Resource Center. The expectation, according to policy, is that if an employee is unable to report for their shift as scheduled, they're required to notify their employing unit 90 minutes in advance. Ms. Schultz did not do so. There is your factual basis. This is consistent. This is applied consistently at WRC, and the treatment is consistent. When it comes down to it, it's a very simple case. Now, you may hear today from Ms. Schultz and her representative claims, allegations, arguments that the department has it out for her, that this is a vendetta against Ms. Schultz, that she is being punished for some reason independent of her inability to show up for work timely. You may hear arguments that the department is executing some sort of conspiracy to punish employees who attempt to take leave. This couldn't be further from the truth. Ms. Schultz has had it communicated numerous times, the expectations for work. Ms. Schultz attempted to have Family and Medical Leave Act put in place. However, this was not done until after the investigation had started. And additionally, FMLA is protecting. FMLA protects leave. It protects your leave time. It protects taking leave, paid or unpaid. It does not mitigate or obviate the requirement that when you are going to work, that you show up for work on time, that you notify your employer that you won't be showing up for work, that you won't be showing up for work on time. Those things are really a sideshow. Those arguments, those claims, those allegations are a sideshow. The central fact, the central question is whether Ms. Schultz was able to comply with the department's attendance policy and her employing unit's attendance policy. The fact is that she couldn't, and it was only after the fact that she made her claims, that she made her argument that this was a mitigating factor. Additionally, as I've said, this is her 5th discipline inside of a year for attendance related issues. The first 2 were written reprimands in lieu of suspensions, but as we all know, that counts effectively as a suspension for the purpose of progressive discipline. In none of the previous 4 disciplines had Ms. Schultz attempted to attribute her attendance issues to her medical issues that are covered by FMLA. And in addition, she had FMLA in place throughout 2025. Again, because that covers leave, that protects your leave. You cannot be punished under FMLA if you're properly taking FMLA for your leave. That is not what is at issue here today. So once we've presented our evidence, we will be asking then the commission to affirm the department's decision to follow progressive discipline and terminate Ms. Schultz. Thank you.
Thank you. Ms. Irwin, do you want to make any opening remarks before Attorney Makovic begins to call witnesses?
Yes, please.
Go ahead.
Good morning. My name is Cindy Irwin. I am the personal representative for the appellant Lori Schultz. And the evidence will show that appellant repeatedly informed management that her chronic medical illness caused flare-ups. The strongest issues that stand out in this case and what we will prove in today's hearing are that the appellant Lori Schultz not only had FMLA certification from her neurologist covering her 2026 late arrivals, but the respondent honored her neurologist certifying the appellant for FMLA in 2025. The evidence will show that appellant repeatedly informed management that her chronic medical illness caused flare-ups that may result in those late arrivals or full days off. The respondent The appellant sought FMLA protection, provided medical documentation from her neurologist, and requested accommodation. Instead of following FMLA laws, the respondent took excessive disciplinary action and a retaliatory stance against the appellant. We will show today that the respondent approved the appellant's FMLA certification in both 2025 and 2026. The federal FMLA regulations specifically recognize that unusual circumstances can excuse strict compliance with ordinary call-in rules. The Americans with Disabilities Act requires employers to engage in an interactive process with an employee once they become aware of an employee's disability. Chairman Davis, we will show today that the respondent failed to follow the ADA guidelines, not only with the appellant, but also with former WRC employee Saj Baldwin, who was forced to endure intense pain and anxiety related to his certified serious medical condition for months as the respondent refused to reasonably accommodate his disability. Saj Baldwin took his own life January 18 of 2024. We will prove that the respondent could have easily accommodated the appellant's infrequent late arrivals and that the appellant should have been allowed to make up her time. The respondent refused to use appropriate discretion for the appellant, which is established within their own policies, which required them to consider all available documentation and information when they applied their discretion. The appellant established her certified serious health condition, and this abuse of so-called discretion is a weakness in the respondent's case. We will use comparators to prove that the respondent accommodated multiple male employees and that the respondent is comfortable disproportionately disciplining female employees. The male employees were not subject to discipline for far more egregious policy violations, but were simply demoted to WRC for admitting to secretly video recording an underage female undressing in his home. That same employee 3 years later arrested for domestic assault. A male employee at WRC pled guilty to strangulation, suffocation of a WRC coworker, and another captain at WRC pled guilty to injury of a person while operating a vehicle intoxicated. These arrests will show how the respondent accommodated these staff by allowing them to keep their jobs with the respondent. The respondent accommodated these male employees by having to separate employees' work posts due to the arrest for strangulation, suffocation, having to cover positions due to administrative leave, clearing a captain through the metal detector wearing a Huber ankle bracelet. All these examples show the respondent's level of accommodation they are capable of compared to the appellant who was terminated for her fourth tardy, which was covered by FMLA certification. Wisconsin also has its own disability discrimination law, the Wisconsin Fair Employment Act, which requires employers to reasonably accommodate disabilities unless doing so would create a hardship. The main points in this case are that there was a stigma created by the respondent for those staff in need of FMLA. The appellant attempted in 2025 to not get FMLA out of fear of retaliation and navigate her serious health condition on her own. This will be shown by the discretion the respondent showed her in 2025 with the progressive discipline and repeated 5-day suspension. Once the appellant was under so much pressure and stress from these repeated formal investigations, she proceeded with getting FMLA certification. Here we are today with this case where the appellant was terminated for a 4th late arrival, which was covered by her FMLA certification in 2026. The appellant was not terminated for excessive tardiness. She was terminated for the 4th tardy, not complying with the 90-minute call-in rule. This makes this case less about her attendance record itself and more about whether the notice requirement had to yield under the specific circumstances of the appellant's disability. The notice issue is clearly resolved in support of the appellant by the mere existence of FMLA law. This distinction is the central issue in the case and cannot be shielded by other claims the respondent attempts to make to shield their unlawful behavior. This hearing is about whether just cause existed. The evidence will show that it did not. The discipline and termination of the appellant should be overturned. The appellant's record cleared, and she should be made whole. Chairman Davis, the interactive process is not a sideshow. As Attorney Makovich stated, it is the law, just for the reasons Mr. Makovich tries to dodge in his opening statement. Thank you. That is all.
All right, thank you for that. Attorney Makovic, are you ready for witnesses?
I am, and I would like to make one note. It's Makovec, not Makovech. I can understand it's an Eastern European last name. It can be challenging there. For my first witness, I would like to call Brittany Keynes.
All right, I see her. I will admit her. All right, Ms. Keynes, I'm Peter Davis. I'm the examiner in this matter. I think you are Attorney Makovic's first witness. I'd ask you to turn on your camera if you would and unmute yourself so I can swear you in.
Hang on. I don't know why the camera's on.
No problem. Take your time. There you are. Very good.
Good.
Thank you for that. If you would raise your right hand and swear or affirm that you're going to tell the truth today.
Yes.
Thank you. Attorney Makovic, your witness.
Thank you. Good morning, Ms. Keynes. I'm David Makovec. I'm the attorney representing the Department of Health Services today. I'd like to start with some introductory questions. First, can you tell us where you are currently employed?
At the Wisconsin Resource Center.
Thank you. Is that part of the Wisconsin Department of Health Services?
Yes.
Thank you. And how long have you been with DHS?
For about 14 years. I started here, went to DOC, and came back. So.
Okay. Well, how long have you been in state service overall?
14 years.
14 years. Okay, great. And since your let's call it return stint, how long have you been at WRC?
I've been back here for 8 years.
All right, thank you. And what's your current position there?
Psychiatric care supervisor.
Thank you. And when you say psychiatric care supervisor, what does that mean in terms of your roles and responsibilities?
So I am a psychiatric care supervisor in the operations department. So I run the line, I do the scheduling, use of force, moves within the institution. And when I don't have the line, I'm just assigned other projects, assisting on the units. And then I am assigned PRIA and staff investigations.
All right, thank you. And when you say staff investigations, does that include investigations into potential misconduct?
Yes,
Thank you. And were you assigned an investigation into some potential misconduct on the part of Lori Schultz?
yes.
All right. And when you were given that assignment to investigate this potential misconduct, what did you get with the assignment in terms of information or documentation?
With the assignment, I got like the 15807 packet, the attendance tracker that we keep for every PCT. And I believe her tardy slips were also attached with that packet.
Okay, thank you. And as a psychiatric care supervisor, were you ever responsible for supervising Ms. Schultz?
No, not directly.
All right, thank you. So then in addition, so once you had that information, what sorts of evidence did you collect in the course of this investigation?
So from there, I just interviewed the PCS that was working that day to get his statement. And then any other documentation that I had was either provided for me or was given to me by Lori Schultz during our interviews.
Okay, thank you. And you indicated you interviewed the PCS that was working that day. Who was that?
John Ostrowski.
All right, thank you. And did he relay whether Ms. Schultz gave any reason for her tardiness that day?
He reported that that day she asked if she could use inclement weather for her tardy.
All right, thank you. I would like you at this point to take a look at a document for me. Do you have a copy of my exhibits in this matter?
Yes.
All right, I'd like you to take a look at exhibit R4 if you could. If you're looking at a larger document, if you're looking at a larger document that might be titled W-E list.pdf, I can point you at a
Okay,
particular
I have
page.
that, yep.
Okay. I would like you to point at page 26 of that larger document.
Chairman Davis, can these exhibits be put up?
I can share my screen.
Okay.
Let me make sure that I'm looking at the right one. Okay. Can everyone see that I've got a screen here that says with a bright yellow stamp that says Exhibit R-4?
Yes.
Okay. And Ms. Keynes, do you recognize this document?
Yes.
And is this the first page of an investigation report that you completed?
Yes.
All right, thank you. And All right, thank you. And when you conducted interviews, how did you make any sort of record of those interviews?
Yes, when I was conducting the interview, I um, would write everything that was being captured in the interview right on the 15807.
Okay. All right, thank you. And then when you um, when you completed your investigation, did you proceed to a pre-disciplinary meeting?
Yes, but not right afterwards.
Okay. Was that on a different day?
Yes,
Okay. Um, and at that pre-disciplinary meeting, did you provide Ms. Schultz an opportunity to present information as mitigating factors?
yes,
And did she do so?
yes. She provided some medical documentation.
Okay. And with that documentation, what did you then do with with your report and your pre-disciplinary materials?
I put everything together and I sent it to our HR director, Gina Ruby.
Thank you. And once you sent that to the HR director, did you have any further role to play in the matter?
No,
To be explicit, did you have any role to play in deciding whether or not to discipline Ms. Schultz?
no.
All right, thank you. At this time, I have no further questions for you.
Thank you. Ms. Irwin, any questions for this witness?
Yes.
Go ahead.
Hi.
Hi.
I'm Cindy Irwin. I am the appellant's personal representative, just so you know. Do you have any papers in front of you?
Just some work I was working on.
Okay, so no documents pertaining to the hearing?
No, well, I have the exhibit up that he just asked me to pull up, but otherwise, no.
Okay. In looking at this exhibit R4, why was Captain Mike Preby the person reporting the allegation?
He would be the one reporting it because after we fill out a tardy slip, he is the one that they go to before they go to HR, I would assume. I guess I'm not sure. But he keeps track of all the tardies.
What is his supervisory responsibilities? Who does he supervise?
I'm going to object to the relevance of this question. How does this pertain to the just cause question?
This is going to show that Captain Mike Preby supervises both the PCTs and the officers, sergeants. I'm wondering if he is a supervisor over all the supervisors at WRC as well.
So whatever the answer to that might be, why do I care what the answer is?
Because Captain Mike Preby, we have exhibits that will show that he has a history of altering and changing policies. Some of those are referring to FMLA staff that use FMLA, which is directly involved in this case.
So I'd say, if he or someone else is a witness to talk about that, that's fine. But I think at this point, who he does or doesn't supervise doesn't really matter.
Okay, thank you. We'll move forward.
Very good.
How did your position as PCS intersect with the appellant in the performance of her job duties?
Um,
So
Like,
I'll tell you, Ms. Irwin, I don't know what that question means. So I'm guessing the witness doesn't either.
Okay. How did you ever interact with the appellant while she was performing her job duties?
I'm sure there were times that, yes,
Okay. Were you a decision maker on any issues relating to the appellant?
no,
Who is the appointing authority of WRC?
Sudahan,
So were you aware of the quality of the appellant's job performance at WRC?
I'm going to object to the relevance of this. I'm not sure why the investigator, why it would matter with what the investigator thought of someone's job performance.
Because the appellant had 28 years of service with the DHS, and with FMLA certification, she was terminated after a fourth tardy. So our exhibits and the question of witnesses is going to show that the appellant was a valued employee at WRC.
All right.
And
So
it's
go ahead.
I was about to say it's my position that that Ginger Steele, the decision maker for the discipline in this matter, is going to be the relevant witness to ask that question of.
Chairman Davis, this witness just stated that Sue DeHaan is the appointing authority of WRC.
So, Ms. Irwin, as you may or may not know, there's a pecking order, I'll call it, in terms of there's a local appointing authority and then there's a higher up appointing authority. Both are appointing authorities. So the witness is no doubt correct about the local appointing authority. But my understanding is Ms. Steele oversees that individual. So they are both appointing authorities. The witness's answer was correct in terms of the local institution. I think Attorney Makovich's correct. This witness didn't have anything to do with whether your client, Ms. Schultz, did or didn't retain her job. She just had a role to play. She played it. And whatever she does or doesn't think of Ms. Schultz doesn't really matter.
Okay, thank you. Did appellant discuss her concerns about being able to comply with the attendance policy due to her chronic medical problem?
during the investigation, yes.
Yes. Do you recall what she had stated?
I couldn't recite what was exactly said, no.
Do you recall the appellant telling you her alleged attendance violations were related to her chronic migraine issues with medication adjustments?
I'm going to object to this line of questioning. We have the exhibits and the transcript of the interviews speak for themselves.
So, Ms. Irwin, I'm inclined to agree. If the document says what it says, and if that's what she told the investigator, it'll be right there, and you can point to that during this proceeding or in written argument.
Chairman Davis, after the investigation meetings were concluded and they were off the record, Ms. Keynes and the appellant held conversations pertaining to the appellant's medical condition and issues. So not all of the conversations between the appellant and Ms. Keynes are documented in the investigative packet.
So then why don't you ask her, did she have that conversation and what was said?
I believe I did that, but I will repeat myself. Thank you.
Sure.
So in those conversations, Ms. Keynes, do you recall the appellant sharing with you that she was having chronic migraine issues and medication adjustments?
And this is after the formal investigation was completed. Is that right?
After they would conclude interviews pertaining to the investigation, they would have conversation off the record.
All right. And that's what you're asking a question about. Is that right?
Yes.
Okay. So
Do you-
witness, if you recall those conversations, you're free to answer.
I'm sure that we had conversations.
I'm going to object to sounds like speculation.
I can't say for sure what was said in those conversations.
Did the appellant bring her migraines to your attention in more than one attendance investigation?
I'm going to object to that question. This case is about a single investigation. Ms. Schultz had an opportunity to challenge each of her prior disciplines, and whether or not she did so, those are not at issue here. The current discipline is for the investigation that we have brought up.
So I'm inclined to agree, Ms. Irwin.
So Attorney Makovic had mentioned progressive discipline. Are you aware that in 2025, the appellant received discretion in the discipline she received as far as like letters of expectation, written letter in lieu of a day of suspension, the repeat 5-day suspension? Are you aware of discretion being used in her prior attendance discipline?
Objection. This is not relevant to her role as an investigator, and it is a question better suited to the appointing authority in the discipline.
So I'm inclined to agree, Ms. Irwin. I expect your next question to be, well, why wasn't it done here? And this witness has no idea what that answer might be.
Okay, thank you. How many investigations have you conducted pertaining to FMLA?
I can't.
I'm going to object to the relevance of that question because this is an investigation related to tardiness.
This is directly related to the appellant's FMLA that she was certified for prior to her termination.
So the role of the investigator is really just, excuse me, take down the facts, if you will, not to make any legal judgments about FMLA or not. So I'm going to sustain the objection.
Okay. Do you recall investigating Daniel Krause for attendance issues?
I'm going to object to the relevance of this. I'm not sure who Daniel Krause is or why he matters to her investigation.
Direct comparator.
So again, this witness does what she's assigned to do. Because you can ask if she was assigned to do that investigation, but
Yes.
That's as far as we're going to go with it.
Yes, sounds good. Thank you. Were you ever assigned to investigate attendance issues with PCT Daniel Krause?
Yes.
Do you recall what his attendance issues were?
And if you don't, you don't. That's fine.
I don't know for sure.
Do you recall what he was under investigation for? What you investigated him for?
I know that I investigated him for an attendance issue.
Do you recall if it was tardies or absences?
Objection.
don't.
She just stated she doesn't remember what it was, what the details were. This is
Do you
asked and
recall
answered.
about when that investigation occurred?
No,
Did you were you ever assigned to investigate PCT Dylan Coons for attendance violations?
I don't believe so.
Are you aware of any staff at WRC who have been tardy, but who have not been written up for it?
I can't speak to that personally, no.
Do you check in staff when you're operations PCS?
Occasionally.
Have there ever been any staff that have arrived late that were not written up?
I have not done that.
Are you aware of any other operations supervisors doing that?
No. I'm not out there with them.
Are you aware of a policy that involves that states that supervisors are responsible for informing employees that they may be eligible for FMLA if they or their family member have a continuous or intermittent health issue?
Yes.
You are aware of that? So did you inform the appellant during the investigation that she may be eligible for FMLA?
We had conversations about FMLA, yes.
What conversations did you have with the appellant regarding FMLA?
Am I just supposed to talk about this investigation?
Yes.
During this investigation, for FMLA, it was already brought up by Lori Schultz that she was attempting to work with her provider to get FMLA.
Would that not be considered a mitigating circumstance for the investigation?
I'm going to object to that. I'm going to object to that question as the appellant had the opportunity to present mitigating factors, and it's the investigator's job to collect information, not to assign statements. Not to assign statements from the appellant as either mitigating or aggravating.
So what do you say about that, Ms. Irwin?
Chairman Davis, we actually have one of our exhibits actually has documentation that she provided in her pre-disciplinary hearing that was not considered.
So that's a different question, but this role, excuse me, are you saying she presented it and the investigator didn't write it down?
Yes, because the appellant was terminated without the mitigating circumstances that she provided.
All right, well, that's a different question, right? I mean, that's a question you're going to be able to ask Ms. DeHaan or Ms. Steele, and they'll answer however they answer.
Okay. How many other prior investigations did you conduct on the appellant regarding attendance?
Now I'm going to object to the relevance of this question.
The witness had asked during questioning if I was referring only to this investigation, which leads me to believe that she may have been involved in investigating the appellant in prior attendance investigations in 2025. So I feel it is pertinent because Attorney Makovic brought this up in his opening statement several times, the progressive discipline.
I mean, I'm going to renew my objection as Ms. Schultz had four opportunities to take her prior disciplines to hearing and did not do so.
So, Ms. Irwin, that I think in the end is the point, that whatever happened in the past happened in the past. To the extent Ms. Schultz disagreed, she had the opportunity to fight with it. She did not do so. What's done is done. Those are part of the record. And whether this witness was part of the investigation, those matters really doesn't matter.
Okay. Would you admit that the appellant complied to the best of her ability with the respondent's attendance policies?
I'm going to object to the relevance of that question. It's the appointing authorities. It's the appointing authorities' call whether or not she complied with the policy.
I'm going to sustain that objection.
Are you aware of any WRC employees who have FMLA certification being targeted for discipline?
No.
I would say that's all for this witness.
Thank you. Attorney Makovic, any follow-up?
No, thank you.
All right, Ms. Kids, you're free to go. I'd ask you to log off and not to discuss your testimony with anyone else. Thank you for your testimony today.
Okay, thank you.
Thank you. Attorney Makovic, who would your next witness be?
My next witness is Ginger Steele.
All right, let me get to the waiting room again. All right, Ms. Steele, this is Peter Davis. I'm the hearing examiner in this matter. Thank you for joining us. I'd ask you to turn on your mic and also turn on your camera, and I will then swear you in as a witness.
Good morning.
Good morning. Thank you. Do you swear or affirm that you will testify truthfully today?
Yeah.
Thank you. Your witness, Attorney Makovic.
Thank you. Good morning, Ms. Steele. As you probably know, I'm David Makovic, the attorney representing the department in this matter. And I would like to start with some introductory questions. First, can you tell us where you are currently employed?
I work for the Department of Health Services, and I work within particularly the Division of Care and Treatment Services within the Department of Health Services.
Thank you. And what is your position within the Division of Care and Treatment Services?
I'm the division administrator.
Thank you. And what does it mean to be the division administrator?
Yeah, so my areas of responsibility include administrative oversight for the 7 DHS facilities. So that includes our 2 secure treatment centers, which includes WRC, Wisconsin Resource Center, the 2 mental health hospitals, Winnebago and Mendota Mental Health Institutes, also the 3 centers for folks with intellectual and developmental disabilities, the Northern, Southern, and Central Wisconsin centers. And then I also support the grant funding throughout the state involving mental health and substance use activities.
Thank you. And as part of that administrative oversight, are you involved in personnel decisions? And does that include employee disciplinary matters? Thank you. And for those facilities that you oversee, are you the appointing authority for the purpose of issuing discipline for those facilities?
So, Ms. Steele, maybe your mic went mute. I missed your last couple answers.
I said yes.
Very good. Thank you.
All right, thank you. And did you, Ms. Steele, pardon, did you have cause to review a potential disciplinary matter for an employee by the name of Lori Schultz?
Yes.
All right, thank you. And what was the ultimate result in this disciplinary matter for Ms. Schultz?
Termination.
Thank you. And what were the work rules that were cited for that termination?
There, I believe work rule number 2, number 5, and number 6, and all of those encompass, they're a little bit overlapping, having to do with attendance and tardiness and following work rules, and as a broad overview.
All right, thank you. And I'm actually going to share my screen here so that you can make sure I'm looking at the right one here. Okay, I'm going to show you an exhibit or a document that's marked as an exhibit. Hopefully you see this one. Do you see
Yes.
a document with that bright yellow exhibit R1 stamp there?
Yes.
Okay, and have you seen this exhibit before?
Yes.
And is this the termination letter that you issued to Ms. Schultz?
Yes.
All right, thank you. And I'm just going to go down to the bottom of page 3. Is that your signature there at the bottom?
Yes.
All right, thank you. And now, talking about these work rules in question here, and I'll pull this up to the page that lists them. Really, with these work rules, the work rule number 2, failure to comply with written agency policies or procedures, is the policy in question an attendance policy?
So, yes, and so that one in particular, I would say, is linked to providing notice of unanticipated leave. The requirement for this particular classification is 90 minutes prior to the shift starting. And then also within there, and this again may overlap, it also has to do with a rule having to do with the third instance of a tardy. That's kind of the trigger, if you will, for discipline going into the 4th.
All right, thank you. Now, for a facility like WRC and someone in a position of a PCT, can you tell us why these policies and work rules are why they are important in this circumstance?
Yes. Punctuality is really critical in these types of facilities because it better assists in a smooth shift handoff, if you will. It can also prevent staffing shortages and can reduce involuntary overtime and also the fatigue that's associated with it. And being on time can assist in assuring that there's no interruption in the operational flow or potentially leave posts unattended, primarily because this could compromise the safety of anyone within the walls of the facility. And as a reminder, the Wisconsin Resource Center is statutorily considered a prison. And so if someone doesn't show up on time, the facility might not know if they're going to be 3 minutes, or 20 minutes, or 4 hours late. And, operationally, we need to plan for that. We don't want to have short staff or run short related to staffing. I think the other piece to consider is minimizing manipulation, if you will, involving the people in our direct care. So these folks can and do observe staff routines very closely. And during shift changes or other schedule disruption, these changes in schedule or inconsistencies can create vulnerabilities that could put the staff and the people in our care or in our charge at risk. And so someone could get hurt. There could be an attempt to escape or an actual escape or worse. And so the rules are very strict for a reason. And boiling it all down, we can't plan for everything within a facility like WRC where we manage so much risk every second of the day. So any practice that we can put into place that is black and white, we try to take advantage of those pieces to place that structure around the work, again, that involves so much risk and so many nuances that we can't plan for.
All right, thank you. When um, so really in this instance, what was it that Ms. Schultz did that violated these work rules in this policy?
Yeah, so it has to do with not making the proper notification before the shift began, which is 90 minutes.
All right, thank you. And when it comes to that policy and the work rules in question, are the work rules and the policy things that are communicated to staff?
Yes.
All right, and specifically in the work rules, does DHS have any any specific documents that contain those work rules and are provided to employees?
Yes, there are several, and there may be other places. There's the work rules that apply to across DHS related to attendance, or I should say, facilities. And then there's the general work rules that we have as all employees across DHS. So there's a couple different instances where this is addressed.
All right, thank you. Now, are you aware, pardon, one moment. Are you aware that in the course of the investigation, Ms. Irwin made some claims about her FMLA-related medical condition impacting her attendance?
Yes.
And when it comes to to tardiness and attendance, how does that intersect with FMLA there?
Sure. So the same rules apply for calling in, and so even if someone is using approved FMLA, there's still the same call-in procedure that is required.
All right, thank you. And when it comes to employees with FMLA, to your knowledge, has anyone at the Wisconsin Resource Center ever targeted or retaliated against employees for exercising FMLA?
Not that I'm aware of, and if that came to my attention, that would not be okay. I'm particularly sensitive to to our workforce, having things going on outside of work. I'll share some personal information. In my lifetime, I have used FMLA myself to care for someone in my family who was very ill. And so I always appreciated that. And, we as the supervisor and I do not know what the FMLA condition is, and I don't want to know. Of course, during this hearing, I've seen what the FMLA, Ms. Schultz FMLA approval is for, but it just doesn't matter to me.
I
If
want
someone
to
has
object. This does not pertain to the appellant. Her expertise is not relevant. Her experience is not relevant to this case.
So I'm going to overrule that objection. I think the witness is responding to is she aware of anybody who singles people out, which is part of your claim, Ms. Irwin? And she's explaining why, if she knew about it, she'd take it very seriously. So I'm sustaining any objection there might be to the objection you're making. I'm overruling it. I apologize.
Okay,
Ms.
thank you.
Steele's testimony will stand.
Okay, thank you.
May I continue?
You may.
Thank you. And so, just again, going back, I lost my train of thought here. So you're talking about the FMLA and ensuring that it's our responsibility as supervisors and leaders and appointing authorities to follow that rule. So, in my opinion, in this particular instance, the FMLA has nothing to do with the disciplinary action.
All right, thank you. And did to your knowledge, or are you aware of what explanations Ms. Are you aware of, or do you recall what explanations Ms. Schultz gave for her 2026 attendance violations?
Yeah, so I think all of the instances were related to FMLA, and then I think after the fact there was a physician who did provide some documentation saying that those instances were covered under FMLA. But again, I'm separating the FMLA from the work rule violations.
All right, thank you. And to your knowledge, as as an appointing authority here, really, what's the purpose of FMLA?
It's a protection for people, right? So they can secure their employment and don't have to worry about potentially losing their job, especially when they're dealing with something that could be catastrophic for themselves, for a family member. So it's that extra protection. Sometimes people if they have a child or a parent or a spouse or themselves, that they need the time away to care for themselves. And I will say, in particular with WRC, people need to be on their game while they're working within those walls, just because of the risk that I mentioned that's associated with that. And so if someone is coming to work and, not fully able to engage, that's dangerous for them. It's dangerous for everyone involved.
All right, thank you. And then looking at the level of discipline, here, this discipline that was issued in that Exhibit R1 that we looked over before,
Yes.
was that following progression, or was that a skip in progression?
It was following progression.
All right, thank you. And then so based on that, is it fair to assume that Ms. Schultz had a 5-day, was at the level of a 5-day suspension previously? And do you recall what really what the what the nature of her prior disciplines were?
I believe they are all related to either tardiness or absenteeism. I think tardiness. I don't remember all of them.
Okay.
Chairman
And
Davis, I'd like to object now because are we discussing her prior progressive discipline?
So, Ms. Irwin, I think you're asserting that progressive discipline should have been followed here or wasn't followed here. And I would understand the question and the answer to go to progressive discipline that's been on Ms. Schultz's record in the past was clearly relevant to whether discharge is the next step. So I'm going to overrule your objection.
So now we can talk about her progressive discipline?
You can talk about that it existed, but not the facts and circumstances. That, again, that ship has sailed in terms of what had happened in the past.
Okay, thank you.
all right, thank you. And Ms. Steele, as a matter of fact, did Ms. Schultz receive a repeat 5-day suspension?
Yes.
And in what circumstances does DHS repeat 5-day suspensions rather than going to progressive discipline?
So if there is one of the reasons can be if it's the time in between when progressive discipline is issued. So for example, if it's over a year within that time frame, then the same discipline can be reissued.
All right, and if it is within a year, is there other circumstances? Can everybody still hear me?
Yes.
Okay,
Yes.
my headset made a beep. I wanted to make sure that I didn't cut out. If it's within a year, can DHS repeat a 5-day? Can DHS repeat a 5-day suspension?
That can be done under the direction of one of the appointing authorities. And we have several, of course. We have the facility leader, and then we also, I'm an appointing authority.
Okay, and is one of the circumstances in which that occurs is for a repeat 5-day for attendance issues?
Yes.
And was Ms. Schultz given a repeat 5-day for attendance issues?
Yes.
And can you explain why DHS issues repeat 5 days for attendance issues rather than going directly to to progression on that?
Yeah, so in this particular case, I can only speculate, and because those disciplines don't come to me. So I only see discipline when there's a skip in discipline or there's a termination. And so I will say that you know, in some cases, the facility leader will make a decision to repeat it, and it's offering a last chance or another chance to the employee. And so that's sometimes we will have facility leaders who are empathetic to a situation and will offer that again.
All right, thank you. And when it comes to the disciplinary decision making process, do you are you I'll ask it directly. In this case, were you presented with any comparative cases for the purposes of deciding on this discipline?
I don't recall. Typically, we are presented with comparators. In this one, though, I don't know that we needed a comparator. I'm sure there are plenty out there. It seems like it's pretty cut and dry. I think what convolutes it is that bringing the FMLA into it, and so it's really there in reading the documentation in black and white, right? That here's the rule, and this is what happened, and then this was the outcome.
All right, thank you. And okay, and when it comes to comparators for, for disciplinary matters. How similar, how similar are you typically looking at in terms of how similar is the behavior you're typically looking at?
So, there's it depends what it is, right? Because every case has nuances, right? We're people and we bring different um fact patterns to the table. And so we look at like this particular discipline, again, it falls within the policies and the work rules. If we're talking about something else that is more like, let's say, there was an issue where a person was being investigated for, I'm just making this up, for bullying. That's a little bit different, right? Because then we have to weigh all the facts and make a decision on it's not as black and white, if you will. So this one, um, I don't want to say cookie cutter, but for a disciplinary a tardy case, it was a pretty standard one.
Okay, thank you. All right, thank you. At this time, I have no further questions.
All right, thank you. Ms. Irwin, do you have any questions for the witness?
Yes, thank you. Ms. Steele, is the appellant being 3 minutes late worth her receiving a second chance?
Uh, Considering the fact pattern and having repeat discipline, no.
Are you aware that the appellant did call to inform supervisors when she would be in?
No.
Can you talk about the risk at WRC?
Sure. So WRC patients, we'll call them patients or residents, are in, again, I talked about WRC being a statutorily uh, classified facility. And so we follow many of the practices, I would say a majority of the practices that DOC follows. And so anytime that we're dealing with folks within the Department of Corrections, especially those with serious mental illness, even just walking in the door is a risk. And so one of the things, and I'll say I'm acutely aware of the risk. I have a history, as many of us do, working in the Department of Corrections. And so walking in the door, we have to be aware. We have to make sure that as much as we can, the shifts are seamless. And so the risk is, risk could be, bringing, we like sharps in or being aware of our surroundings, right? The red and yellow and green alert, when we should be alert. So it's constant risk.
Okay, so you said it wasn't about the notice, it was about the pattern. The pattern, correct?
Yes.
Okay.
It's about both, right? They're both.
Yep. Okay,
They're
thank
both
you.
important,
Thank
sure.
you. Yep. Chairman Davis, are we able to bring up Exhibit A24, please?
If Attorney Makovic is willing to give you the courtesy of sharing his screen with that exhibit? Yes.
Sure.
Thank you.
All right. I'm going to, here we go. Are we good here? Is this it?
I can
Yes,
see it.
thank you. Do you recognize this policy, Ms. Steele?
I do.
And this is a policy commonly referenced in your business?
Yes.
Okay. If we can go to page 2 of 7, please, Mr. Makovic.
Two of seven.
Thank you. And if we can go down to where it says serious health condition.
Should be on screen now.
Under if you can move down further, it's under Wisconsin FMLA, under that heading. Yep. And Ms. Steele, were you aware whether or not appellant's FMLA certification included a serious health condition?
Yes. Yes.
You were aware of that?
Yes. I think it has to be a serious medical health condition to even be approved for FMLA.
Yes. And then if we can move Mr. Makovic to page 4 of 7, where it states supervisors are responsible for. Are you aware, Ms. Steele, that in this policy, it states that supervisors are responsible for informing an HR representative if employees under their supervision miss work for a serious health condition for more than 3 days? And they're responsible for informing employees under their supervision that they may be eligible for FMLA. Are you aware of that?
Yes, I'm reading it right here. Yes.
So as you were discussing earlier with Mr. Makovic, do you have any knowledge as to why the appellant, when she was going through the progressive discipline in 2025, why she was not informed that she met the criteria for FMLA?
I'm sorry, I don't know that.
You stated that you decided that the policies, the attendance policies, overrode the FMLA protection. Is that correct?
Yes. And there's context around that, right? Like,
I just asked
Yeah.
you the question. I didn't ask for
Yes.
context. Thank you. So you did admit that you decided that policy overrode. I just
Yes.
want to make sure. Yes. Okay. Attorney Makovic, can you please bring up Exhibit A7 for Ms. Steele?
Do you have a page number on that? I need to like scroll through these manually. It's a long way.
Yes, we have them bait stamped, so that will be 26.
Oops. Five. Okay. The page numbers don't line up with the PDF page numbers. Okay, here we have one. A7.
Thank you so much. Ms. Steele, have you seen this document before?
Yes.
You have. So do you recall that the appellant was under the treatment, has been involved in ongoing treatment with this neurologist since August 11th of 2023?
I am now.
Did you review this document prior to deciding you were going to terminate the appellant?
No.
What is the date on this document?
March 4th, 2026.
Do you recall what the date of termination of the complainant or the appellant was?
I think it was January, but I'd have to look at that.
If, Mr. Makovic, if we could please bring up, A4, which is appellant's termination letter for Ms. Steele. What is the date of this letter?
April 2nd, 2026.
What does this document state?
This is, can you scroll down, please? I believe I just want to see the bottom. If it's a termination letter, if my signature is on it. It's the termination letter.
I believe
Okay.
this is an exact copy of my exhibit R1.
Yes. So you decided for termination of the appellant, but you did not consider the mitigating factors that she provided during her pre-disciplinary hearing?
No.
Why did you not consider the appellant's neurologist's medical documentation in your decision to terminate her?
2 reasons. I'm not privy to that information. I just saw this during discovery. That's one. So I guess the other reason it wasn't provided to me.
As the appointing authority, why would you not be given all of the pertinent information regarding an employee that is facing termination?
I think that the Bureau of Human Resources is very protective of the FMLA and ensuring that it's a HIPAA violation, a privacy violation. So I'm guessing I certainly don't make that decision.
So were you aware of the appellant having FMLA certification from her neurologist
I was
months
aware.
prior to her termination?
Yes, I was aware that there was an FMLA certification that came in after the fact, but I didn't know who it was from. I'm not notified as far as what their practice is in professional practice.
Can we bring up A18, please, Mr. Makovic?
Do you have a page for me?
Yes. 53 to 62. And Chairman Davis, do you want us to request to admit each exhibit we introduce, or did you say in your email we were going to do that at the end?
We're going to do it at the end.
Okay, thank you so much. If we can scroll down, did you review this 15807 packet of the appellant?
Let me look through it here. This is, I believe so, but some of these are blended together, so I don't know how many pages this is. I refer to it as is it the EIR? Is that what you're referring to?
This is the 15807 packet. It's Division of Personnel Management, DOA 15807. This particular page is B. What do you
Yes.
refer to the packet as?
So I refer to it when I receive these, it's the EIR, which is the heading, it's the Employee Investigation Reports. So I think we're talking about the same thing.
Okay. And can you see here that on March 13th of 2026, what does it state occurred?
Says pre-disciplinary meeting held.
Okay. Are you aware that complainant or the appellant provided her FMLA paperwork as mitigation in her pre-disciplinary hearing?
I am, and I don't think I saw that.
If it was provided, why would you not see it?
I'm not sure, but if it was provided, I'm going back to the disciplinary fact of the attendance violation, right? We can scroll down. I don't think any of that, Mr. Makovic, if you were able to, I don't think any of that is in there. It might be like a overview of the FMLA or anything that Ms. Schultz might have talked about within her interview. Yeah, so I think it references it, but there's not the exact, and that might not be what you're asking. I didn't have the exact paperwork, just what was discussed during the interview process.
It does, do you see it does state here that Lori, the appellant, has a serious health condition that prevents her from arriving to work
Yes,
on time?
yes.
So did you consider that at all and decide to review what she provided during the pre-disciplinary meeting?
So two questions. Did I consider that? I mean, I read that. I again was looking at the work rule violation. And then what was your second question?
If the appellant clearly notified the investigator during her pre-disciplinary meeting that she had FMLA certification, a serious health condition, why did you not review what she provided during the pre-disciplinary hearing to understand what her serious health condition was?
Yeah, so I think that we're talking about the from what I understand, the FMLA paperwork documented that she could be late to work, but she also would need to make that notification within that 90 minutes.
Can we go to exhibit A1, please? And you recognize this as the appellant, her name,
Yes.
and that this is the certificate from her healthcare provider for her serious health condition, correct?
Here so, yes.
Okay, if we can scroll down, please. And if we could hold up right there, go up one page, please. Do you recall ever noticing that the approximate date the condition started was at age of 8?
Yes, I see that.
Do you recall being aware of that at any time during your decision-making process to terminate the appellant?
No, I didn't have this document.
Okay. Do you also notice that when it says for the healthcare provider to provide the best estimate of how long the condition lasted or will last, do you see that it says lifelong? I didn't hear you.
Yes.
Okay, thank you. And you can see that it states it's a chronic condition, correct?
Yes.
Okay. Have you ever had migraines?
Are you talking about my personal health information?
Are
That's
you
you're wanting to know?
familiar? Are you familiar with migraines in general?
Yes.
Yes. And you're familiar with how debilitating they can be?
Yes.
and you're familiar with how they can come up out of nowhere,
Yes.
creating brain fog. And can you describe what knowledge you have of migraines and their symptoms?
Sure. There can be
I'm
aura. So
I'm actually going to object to further questioning on migraines. We've established that there is a serious health condition that was attributed after the fact. I'm not sure the details, how much the details matter.
The brain fog,
So,
the
so
brain
Ms.
fog is important.
So Ms. Irwin, I mean, Ms. Schultz will testify as to what was or wasn't going on in the day in question. Backing all the way up, as I understand it, the employer's position is it does not matter. It does not override the obligation to call in timely. So their
Exactly.
position is FMLA is irrelevant to how this turns out. So you're pursuing the FMLA issue. That's fine in terms of making your case, but
Yep.
understand their view is they had no obligation to consider it. It does not excuse her failure to call in timely.
Yes, thank you. Is it safe to drive? Is it safe for a person to drive when they are having a migraine?
Again, I'm going to object to the relevance of this question here because it's about the notification.
So, Ms. Irwin, I'm going to sustain that objection. Ms. Schultz can testify as to whatever was or wasn't going on that day in question. And if it turns out that matters, so be it.
Okay, thank you. Can we scroll down, please, Mr. Makovic? And do you hold up? Yep, if we can write on those dates. Right, yep, you were good right where you were at.
Do I want to
Right.
be on A1, page 3 of 4?
Yes, right there. So did you, Ms. Steele, you said you did not review this document at all before deciding on termination, correct?
correct.
Okay. Looking at this now, do you believe that this should have been considered by you?
No.
Do you notice that patient was established since 2023 there, and the 2025 dates are included in this FMLA?
See this? Yes.
So how do you justify that an employee with a serious medical condition that has flare-ups, and if we can scroll down a little bit to look at the occurrences, these occurrences over the next 6 months, it says episodes of incapacity are estimated to occur once to twice per week and are likely to last approximately 1 to 3, I believe it's hours. We can't see the right side of the document.
It's days.
Days, okay. Ms. Steele, is this an accommodation that could have been made by you?
I don't make accommodations. So no, I'm not involved at all with accommodations.
Are you aware of reasonable accommodations in DHS?
Yes.
Is it the employer's responsibility when an employee is certified with FMLA for the employer to work with that employee?
I'm going to object to the relevance of that. Working with the employee on accommodations is an ADA question, which is not within the jurisdiction of WERC. Additionally, this is the evidence does not show that there were requests for accommodation made prior to these tardies. And additionally, this is a case about failing to abide by the proper notification required within a policy.
Is the FMLA coordinator at WRC, would he be responsible for informing employees of their rights under the Family Medical Leave Act?
Again, I'm going to object to that question. This is a disciplinary matter, not an FM, this is not filed under any statute that covers that covers allegations of violations of FMLA.
But per the respondent's own policy, the supervisors are responsible for informing employees when their serious health condition or family health condition meets the criteria for FMLA. So I feel that my question is valid because WRC does have an FMLA coordinator. How are employees supposed to know about their rights if they're not informed?
So, Ms. Irwin, and I don't know the answer to this question at the present time, but the state's view is that this is not an FMLA issue. So informing Ms. Schultz as to FMLA rights would not excuse the requirement that she call in on time. So I think that's their position. If you have law that says otherwise, I assume you'll direct me to that. I think Mr. Makovic is also correct that this accommodation process, to the extent I'm aware of it, requires that the employee initiate it first. It's not an obligation on the employer. The employee needs to initiate the request, and then the employer responds. So unless there was a request from Ms. Schultz prior to this last tardy, I don't think it's going to matter.
Were you aware of the appellant making an ADA request
No,
in March?
no.
Would you say that the Family Medical Leave Act should be an interactive process between the employer and the employees?
I'm going to object, as Ms. Steele just stated, that the FMLA process goes through an FMLA coordinator and not her.
Chairman Davis, you refuse to allow us to have the FMLA coordinator at WRC be a witness.
Yeah, that's true. And I think the point here is the witness has indicated she did what she did and why she did not consider it. And to the extent you think that's violated of the law, you've proved your case. So you've got what you need if it turns out you're right as to what the law is.
Okay, thank you. Let's move on to comparators, Ms. Steele. Attorney Makovic, can we please move to Exhibit A24?
Page, please.
83. And then we're going to go to page 4 of 7 in that exhibit, please. Oh, I'm sorry. Can we go to A17? I got the exhibit wrong. I apologize.
Page, please.
A1745.
Oh, and you wanted page 4 of that document?
Nope, if we can just slide down to work rules, go up just a touch, right there. So do you see do you recognize this policy? This is the DHS work rules and discipline policies and procedures? And how many years of service do you have as the DHS administrator? Is that what the title is?
The administrator, yes,
Yes.
during Governor Evers' second term, so starting, going on 3.5 years.
Okay, so are you familiar with this policy that work rules are also enforced outside of work?
Um, I'm not sure I understand your question.
I'm going to object to the relevance of this, as it appears to lead to a question about disciplines for other employees involving out of work behavior or conduct, which under the Morris standard is completely irrelevant to a similarly situated employee.
Chairman Davis, this shows that this witness has completely accommodated staff members at WRC who have criminal convictions, who was transferred to WRC after he admitted, these are all males, after.
So Ms. Irwin, I'm gonna cut you off. But Attorney Makovic is correct. Under the WRC's current rulings, comparators going to be limited to other scenarios involving tardiness. So what they do or don't do in other circumstances is not relevant to this proceeding.
Are you familiar with any other staff at WRC who had excessive tardies?
I'm sure there were. I don't know. We have 4,200 employees, so I'm absolutely sure that has happened.
Yes. Have you discussed with Director Sudahan whether or not to terminate other WRC employees for excessive tardies?
So I don't directly discuss this with Sudahan. I only see, are you asking about termination? I'm sorry. Was it termination or any discipline?
Yeah, termination, because you
Termination.
decided on the appellant's termination in this case. So
Gotcha. So you're asking if I discuss other terminations with Sudahan? Is that what you're asking?
regarding attendance, tardies, anything that's similarly situated to the appellant.
So, and I will answer your question. So to clarify, I only see these for skip and discipline or termination. And so you're asking about similar situations. If it was something that was similar where someone was being terminated or there was a skip in discipline for tardies, what happens is so I would discuss this with Sudahan, and then we have a group that gets together. So it's the appropriate facility leader. We also have representatives from our Bureau of Human Resources, and then we also have representatives present from our Office of Legal Counsel, as well as the assistant administrator who's assigned to that particular facility. So the answer is yes.
So did you hold one of those meetings with all of those staff to discuss the appellant?
That one I don't remember. Because this one was pretty cut and dry. I'm sure we would have. I just don't recall that. I'm sorry.
Why would you say it's cut and dry if the appellant had a lifelong serious health condition and was certified for FMLA? Wouldn't you take consideration? You said you were very sympathetic to FMLA. Wouldn't you take consideration for an employee who had a serious health condition?
Again, the same answer that I'll provide is this was separated from the FMLA decision. I didn't have all that information. I'm not privy to that.
So because you were not provided with that information, her FMLA certification and her neurologist submissions to in her predisciplinary hearing, you just determined this was cut and dry, correct?
Yes.
Okay. So you do not consider FMLA when you terminate an employee?
I'm going to object to that being a very broad question about a very specific case.
Can we
So-
go to A5, please? Page 12 on the Bates stamp.
Page 12.
And just going back, Ms. Steele, wouldn't you say that it's a tricky place to exist when considerations for FMLA protections are not considered?
A tricky, so are you asking about in my role when it's not considered? Is that what
Yeah,
you're
in
asking?
your
Yeah.
role, doesn't that get when you're deciding to terminate an employee, aren't you supposed to consider mitigating factors, especially FMLA?
So in this particular case, if this one, and the reason I say I want to clarify that when I say cut and dry, because that's like an absolute. So in this particular case, it was pretty clear that this was an attendance issue. If there is a case where there is, I mean, every fact pattern is different, right? And so we would evaluate what's happening in the person's life. I mean, we look at the person as a whole. This one's a little different because it's a clear attendance violation case.
But you can understand with what we've presented so far that there was it was clear that she was suffering with these medical issues that was expressed in her predisciplinary hearing. And aren't there any protections for employees that have serious health conditions?
Yes, it's FMLA.
So how can that not be considered if it was provided in her investigative packet?
So couple things. I have only what the employee reported, right? And so I'm looking at the employee's responsibility for calling in, just like everyone else, FMLA approved or not, for calling in prior to the shift. That's what I was looking at.
But when you saw in the 15807 packet where the appellant stated she had the serious health condition, she went through the proper steps to get the FMLA certification the month before you decided to terminate her. Would that not have been worth giving her a second chance?
No, and I like this is the same question, right? Like that was not considered in this particular case, so no.
Were the appellant's 28 years of service considered by you?
In this particular case, or just in general?
Yes. Nope. In this case,
Yeah.
28 years of service.
Yeah, no,
You didn't consider her 28 years of service either.
no.
Okay. Are you aware of any other prior attendance issues prior to 2025?
With Miss Schultz in particular?
Yes.
Yeah, I think that's documented in the EIR.
So there were the 20, if we can go to, if we can go back to Exhibit A18, please, to review those past occurrences. '53.
Sorry, were you saying A18 or A17?
A18. The EIR is what she called it.
A18, page 1 of 10, employee investigation reports.
Yep, and if we can scroll down to where her prior occurrences were.
So the listing of her prior disciplines,
Yes.
I believe that'll be in the page for included exhibits, or the exhibits that were included. Oh no, the prior disciplines. Here we go. This page here?
Yes. So, Ms. Steele, can you see here that the appellant had no attendance issues from 2023 until May of 2025? Do you see there was quite a gap in there?
I see what's right in front of me. Yes, it looks like 2023 on the bottom row and then 11/4/2025 on the top row.
Okay. Chairman Davis, can we address, it appears as though this witness may be on her phone. Are phones required to be flipped over in this forum?
I'm not on my phone. I have a notification, but I'm not on my phone.
Okay. Can we request that the phone be turned over, Chairman Davis?
So why, Ms. Merwin?
It's just a concern that she may be distracted and we need her full attention.
Phone's on the other side of the room. You're hearing a notification from my computer, a notification.
Okay. So if we can see here, did you consider that there were no attendance issues between 2023 and mid 2025?
Yeah, I did see that. I did read that in making this decision.
Okay, so did you not consider that with her stating that this was a serious health condition that suddenly arose for her, that she's been dealing with her whole life since 8 years old, that this would just be something that she would need FMLA in order to work through this serious health condition?
So can you restate the question? I'm not exactly sure what I'm answering.
This is within a year's time, from May 19th of 2025 to February of 2026. So it's actually not even a year's worth. And she went to her neurologist. She got certification for FMLA. Why would you not see that this was a flare-up of her condition? And why would you not consider that as a mitigating factor when you decided to terminate her?
I was following policy.
So again, policy overrode you said you were sympathetic to FMLA, correct?
I did.
You did. And you stated that you used FMLA in the past, correct?
Yes.
So why would you not be sympathetic to an employee's serious health condition with her neurologist's support?
Well, bringing up my own FMLA, I followed policy and procedure when I had my own FMLA. And so that's what I'm considering.
So per the policies, do they not allow discretion for consideration in these decisions?
Some do.
Can we go to A5, Bates number 12, please? And we'll go to page 3 of 3. So do you see below where it states, if we could scroll down just a touch. Can you see that staff in relievable positions are generally not able to make up their absences?
Let's see. It says, which one are you referring to?
Staff in relievable positions are generally not able to make up their absence.
See that? Yes.
So generally, does that not create space for discretion?
For relievable staff, yes.
And Attorney Makovic, what does it state beside supervisors may grant an exception if extraordinary circumstances apply? Do you see that?
Are you asking me or Attorney
Yes,
Makovic?
yes, I'm asking
Oh.
you. I'm sorry.
Oh, yeah,
I'm
I see
actually
that.
going to object to further questioning along this line because this is not a case about making up absences.
So, Ms. Irwin, I think he's correct about that. This is about calling in a timely manner.
I just wanted to highlight that that there is discretion that was used by the respondent. The past discipline, we've acknowledged that she received repeat of a 5-day. So Ms. Steele, with the repeat of the 5-day, were you involved in that?
Oh.
So what moved the appellant's situation from you not being involved in the repeat 5-day, but then you being involved in her termination? How does that move to you?
So it's a recommendation that comes from HR and the facility leadership. And so it would only come to me if they had pushed it forward as a skip in discipline or a termination.
So then was this a skip in discipline determination?
Oh, it followed the progressive discipline, so it went to termination.
So is there a level of discipline after a 5-day? Is there ever a 10-day suspension allowed?
Not that I'm aware of.
We can move to A6, please. Bates stamp page 15. And page 4 of 11. We're looking for the appointing authorities are responsible for consistently applying and enforcing this policy. So are you aware of the director of WRC, if she was using discretion with repeating the 5-day, giving the written reprimands in lieu of the 1-day and the 3-day?
I'm
Would
going to
you-
object to this question. The record of the prior disciplines show that Ms. Schultz already received discretion by getting written reprimands in lieu of 1-day and 3-day, and a repeat 5-day as well.
Yes. So she received discretion even prior to receiving the FMLA certification. So with FMLA,
Yeah, I'm gonna renew that objection. That I'm not sure of the relevance then.
with FMLA certification, there should have been increased discretion and consideration for that being a mitigating circumstance prior to her termination.
So is that a question, Ms. Irwin?
No, I'm stating that she received as attorney.
No, I get it. I get it. I'm just saying that's a statement. That's fine. We're asking questions of the witness.
Yes.
All right. So if you got a question, go ahead and ask it.
Okay. Can we bring up A1963, Bates stamp 63? Ms. Steele, did you review this decision at all before this case came to you?
I'm not sure what exactly it is. Could we scroll down? Yes, I'm familiar with this case. Not, I received the decision. It came to my attention before this case, so I knew about it.
Yes. Can you please share what knowledge you have of this case?
Yeah, so and not re I have to refresh my memory, but just off the top of my head without rereading it, there was an employee at Winnebago Mental Health Institute who I believe had FMLA, and there was some type of disciplinary action. And I don't know if it was, I just don't recall if it was a skip or if it was a termination. And the WERC, I think, reversed or reissued the discipline.
Okay. If we can scroll down to it would be page 7 of 11. And it's the paragraph that starts with the court determines. Do you see here that the court determined that WERC was legally authorized to consider mitigating factors as determined by the facts and circumstances of the case in its just cause analysis in order to come to its determination?
I'm going to object to further questions about Ms. Steele's knowledge of WERC's authority and jurisdiction, as I believe that falls under argument.
Ms. Steele is familiar with this case, so I just want to use this to refresh her memory because this was a case where this PCT under her supervision was terminated. Oh, excuse us. Sorry. Was terminated and WERC overturned that decision.
So Ms. Irwin, Attorney Makovich's right. This is argument you're going to make as to why you think Schultz's case is like Im's case, and it'll
Okay.
take you wherever it takes you.
Sounds good. Thank you. In regards to the IMS case, Ms. Steele, did you consider that that overturning of his termination? Did you consider that in this case at all?
No, I don't recall.
How did you get informed that Mr. Ims was reinstated after he was terminated from Winnebago Mental Health?
I received an email from, I'm not sure, I'm on a distribution list of folks who are involved with the case. And so it would have come to me, I'm not sure by who, but via email.
Are you aware of when you received that notification?
I'm sorry, I don't recall.
Approximate year, was it 2024?
Oh, gosh.
Objection, she just stated she can't recall.
Okay.
Or sorry, she stated she does not recall.
Does terminating an employee, you had stated how important it was to have employees reporting on time and calling ahead of time. But does terminating an employee, does that create a staff shortage?
Yes.
Did you consider creating a staff shortage when you decided on termination of the appellant?
No.
Did you consider that with FMLA, the appellant would have been able to address her serious health condition?
Don't recall.
Are policies an integral part of DHS operations?
Yes.
Can we bring up exhibit A20, please?
Page, please.
$74.
74. How are policies changed in DHS?
Like the technical piece of it, or who decide? What's the question exactly?
Yes, when there's established policies, DHS policies, you can see this applies to the DHS 24/7 facilities. And can you describe when an institution wants to change a policy, how does that work?
Sure. So
I'm
if
going
it-
to object to
Right.
this question. I'm not sure the relevance of a policy that was changed after Ms. Schultz's termination, how that's relevant or matters to this to the circumstances of this case.
Chairman Davis, the witness stated that FMLA was not the appellant's FMLA was not considered as a mitigating circumstance in her termination. And here we have the respondent restricting trades for staff with FMLA. So this shows a pattern of staff with FMLA certification being targeted and retaliated against by the respondent.
So I'm going to sustain Attorney Makovich's objection. Again, their legal position is FMLA is irrelevant to why your client, Ms. Schultz, was terminated. So what they do or don't do with FMLA under other circumstances, I think does not matter. I should clarify, it does not matter in this proceeding. If you think they're doing something illegal, there's another agency to turn to for raising that issue.
Yes, we're already filed with that. Thank you. I would say, do you have any recollection, Ms. Steele, of Saj Baldwin and
I'm going to
his
object to any questions
FMLA
on.
certification?
I'm going to object to any questions about Saj Baldwin. He's a very different he was a very different situation, and it also occurred for years before the start of this matter.
Saj Baldwin is a direct comparator. He received FMLA and it was completely ignored as it was in the appellant's case. And he was, and it shows that his reasonable accommodation request was not followed by the respondent. So we would like to introduce that and see if Ms. Steele has any knowledge of Saj's FMLA.
So I'm going to sustain Attorney Makovich's objection. Again, their position is FMLA is irrelevant to this matter. If it turns out they're wrong about that, then you may win the case. What they did or didn't do in another circumstance as to FMLA does not matter as to why they terminated Ms. Schultz.
Okay, thank you, Chairman Davis. It doesn't hurt for us to try. Then we rest with this witness.
All right, Attorney Makovich, any redirect for the witness?
Yes, one moment, please. All right, thank you. I'm going to stop sharing here, but I have some questions that I'm going to address with my own exhibits. Yes, so here we go. There we go. We should hopefully see exhibit R4. Some redirect questions for you. Ms. Steele, to your knowledge, did Ms. Schultz have FMLA in place at the time of the the 4 tardies in question here?
No.
And did she request retroactive FMLA after the fact? And for
I'm sorry.
her,
That's right. I didn't hear the answer to that.
So sorry. I think my microphone's having issues. I said yes.
Thank you.
and do you recall, Ms. Steele, do you recall seeing the tardy slips within the exhibits of the employee investigation report?
Yes.
All right, and I would do you recall if those tardy slips, if any of those tardy slips identified the reasons for tardies?
They did not, I don't believe.
All right, I'm going to go to the page with the tardy slips here. Here I'm in exhibit R4, and this is actually, funny enough, exhibit 4 within the EIR. So does this appear to be the tardy slip for January 8th?
Yes.
All right, and then I would like to look at the next page here. Does this appear to be the tardy slip for January 16?
Yes.
And is there a handwritten note at the top?
Yes.
All right, and can you read that, or would you like me to? I know it can be tough reading on somebody else's screen.
Yeah, I can see it. It says requested inclement weather, snowing 2 to 3 inches. Nobody else was tardy.
All right, thank you. Does that seem like it should be accounted for when discussing FMLA?
You know, with me not having any say in what's approved in FMLA, I think that didn't raise eyebrows, I think, until the physician that sent through the approval days included this day. So I think I just took this, if I would have just seen this on its own, it would have been like, okay, this is just a note. Someone was tardy because of the snowfall. But when it came back as an FMLA approval, I just wasn't sure what to think of that.
And then we have a third tardy slip, which I will admit is very hard to read. And then our fourth tardy slip here. And is this does this appear to be the February 20th incident?
Yes.
All right. And do you see it in the leave there where it says ULWOP? Do you know what that stands for?
Unauthorized leave without pay.
All right, thank you. And was Ms. Schultz disciplined for taking leave without pay?
No, it was because of unauthorized leave without pay has to be approved by the appointing authority, but this was part of the notification process as well.
All right, thank you. And when you reviewed the employee investigation report, do you recall whether that employee investigation report contained exhibits with it?
Before the hearing?
Yes, when you
Yeah.
reviewed it for
Yes.
the discipline.
Yes. So I didn't see in there, I just had a recap of what those tardy slips said, but I
Okay.
didn't see the actual tardy slips.
Okay. And I'm going to go down a little bit here. Now, was that included at least in part in this description of final conclusion?
Yes.
Okay. And do you recall, I know it's on screen right now, but do you recall that this description of final conclusion did include discussion of Ms. Schultz claiming a serious health condition?
Yes.
Okay, and I think when it comes to a discussion of the when it comes to a discussion of the reasoning or any mitigating circumstances behind a discipline, if it's related to a health concern, do you need the specific details of the health concern, or do you feel comfortable relying on the conclusions and the conclusions and summaries about the health condition?
I rely on the information that I have in the EIR.
Okay. Um, all right, let me just check my notes for a moment here. When it came to the decision-making process, and the disciplinary decision, how much, if at all, did it matter the fact that Ms. Schultz did not have FMLA in place at the time and requested it afterward?
Yeah, I mean, I think again, this is just for me, if I had a serious health condition, I would be absolutely sure that my job was protected. I would want to make sure that I know this is an ongoing issue. I want to be sure, and for me, like need my job, that I have this in place. If it's something that's annual every year, I would want to make sure that for me, I'd want to make sure that was in place. So absolutely did consider. I questioned why that wasn't in place.
Mm-hmm. Okay, and at the time when Ms. Schultz had a first tardy on January 8th, could she have made requests to get? Could she have made requests to get FMLA to have that? Could she have made a request to have? Could she have made a request to have that covered under FMLA?
Yes, I mean, at any time, the FMLA could have been requested at any
Okay.
time along the way. Yes.
Okay, and then if she had FMLA in place, would she still have been required or beholden to the call-in requirement for the attendance policy?
Yes.
And to your knowledge, for any of these 4 tardies in 2026, did she call in advance for those tardies?
Not that I'm aware of.
And had Ms. Schultz had FMLA in place in the past?
Yes.
If someone has had FMLA in the past, do you find that they're able to request to put FMLA in place?
Yes. Each year, once the hours expire, the calendar year, they can certainly continue to request that.
Thank you. I have no further questions.
Any follow-up, Ms. Irwin?
Yes, can we go back to those tardy slips, Attorney Makovic?
Yes.
Thank you.
Here we go. Number one.
Do you notice on this tardy slip, there is nothing in the time call box?
That's correct.
Were you aware that the appellant did in fact call the institution?
No,
Okay, can we move to the second tardy slip? Do you notice in this tardy slip, the time call is also blank?
there's a hyphen there.
Yep. And if we can scroll down to the third,
I'll rotate this one.
thank you.
Here we go. It's very faint. It may be a little bit more readable on mine. It looks like time call, if I may.
Yes.
It looks like 05. I can't read that third number, but it's 05 something 3. It might be a 5, might be a 1.
Okay. So you can see, Ms. Steele, that the appellant did make a call.
It looks like it on here. Yes.
Okay.
At 5:13 a.m. maybe? I'm not sure. I can't tell.
Why do you think the other time call, do you have any knowledge of why those would be blank?
No, I mean, my guess was that there wasn't a call, but I have no idea.
Okay. So when the appellant testifies and she states she did call, would you consider that a breakdown in procedure?
Yeah, absolutely. If
Okay.
someone calls in and it wasn't, yes,
Yes.
yeah.
Yes. Okay. Thank you. And then if we can go back down to where the appellant made her comments in her pre-disciplinary hearing, please.
Oh, I rotated it the wrong way. Okay. Pre-disciplinary meeting.
Yes. So can you see here where she states, I thought my FMLA from last year that started in October 2025 went for 12 months.
Yes.
So would you also state that the FMLA coordinator should have informed the appellant of the length of her FMLA coverage when she received it?
I'm going to object to the relevance of that question because it's really discussing whether it gets a lot into the expectation that the expectation of FMLA and applying for FMLA, which was not in place at the time.
As you can see, Ms. Steele, though, this is, she had FMLA in October 2025, correct?
Based on what I'm reading here, yes.
Yes. So do you recall reading this her statement when you made your termination decision?
Yeah, I don't recall reading this, but if it was in the EIR, I would have read it.
Wouldn't this be a key point as an employee is dealing with a serious medical condition such as the migraines, the brain fog, and she's navigating trying to get to work on time, that it would be reasonable to see where she would, without instruction from the FMLA coordinator, that it's reasonable for her to believe that this would have lasted for 12 months.
So I'm going to jump in, Ms. Irwin. Two things. I don't know this for sure, but I'm guessing somewhere there's a document that specifies the duration of FMLA. I don't know that for sure, but I'm guessing it says what it says. Secondarily, the employer's point here is that if she thought she was an FMLA, why didn't she say that when she called in instead of saying it's snowing or I got picked up for speeding, right? That's their point. If you got FMLA or you don't, but it's your migraines, normally people would say that instead of it's snowing, I'm going to be late, I got picked for speeding, I'm going to be late. That's their point. So long story short, I'm going to sustain Mr. Makovich's objection.
If we could go back to A1, please, the certification of the FMLA.
Guessing we want to be here.
Yes, we're looking for page 3 of 4, amount of leave needed. Yep. And right above amount of leave needed, do you see it says this form is to cover dates of incapacitation from 1/1/26 to 12/31/26?
Yes.
So if this covers a year, was it reasonable for the appellant to believe that her October FMLA would have reached into January and February of 26?
I'm going to object as this calls for speculation into the appellant's mental state.
So, Ms. Irwin, Ms. Schultz can certainly testify as to that. I'll
Yes.
go back to the fundamental point, which they may be right or they may be wrong, is it does not matter from their perspective. That's your
Okay.
case. They've made your case to the extent you turn out to be right as a matter of law.
Yes. Thank you so much, Chairman Davis.
Anything else for this witness?
Could we just get a 5-minute break to confer and take a small break? Would that be possible?
Certainly. Any objection, Attorney Makovich?
I would ask that we determine whether or not we're going to continue or release the witness before we take a break. She's been on the stand for like 2 hours now.
Yeah, I would like to take a 5-minute break, and then we would have just a couple more questions for the witness.
All right. Given that we've been going for a while, I'm going to allow a 5-minute break, just be it on bathroom use or otherwise. But then I hope you will be ready for whatever questions you have for this witness so that she can go about her day.
Yes, thank you so much.
All right, let's take 5 minutes. All right, potentially, I think we could go back on the record.
So, are we ready to begin, Chairman Davis?
We are.
Okay. Ms. Steele, are you aware of the appellant when she called to inform the supervisors of her late arrival? Are you aware of her giving any reasons during those calls?
No, not that I can recall.
Okay, because you weren't aware that she even called, correct?
That I can recall.
Okay. Then I think we are, would, just a couple more. Would you say, Ms. Steele, that there's equal application of, policy in regards to staff who have, FMLA and their termination?
I would sure hope so, right? Like, yes, I'm gonna say yes, but I don't know what I don't know, right?
Yeah, and so you were aware of the PCT IMS who was reinstated by the WERC's decision, correct?
Yes.
And you were aware that was based on his mitigating circumstances overrode the DHS policies that they used to terminate him, correct?
No, I don't know that for sure. I can't remember if it was something that was mitigating or if there was like I just don't remember the fact pattern on why that was reversed.
Okay. Then I think we are good to rest with this witness.
Attorney Makovic, any follow-up?
No, I'm good. Thank you.
So, Ms. Steele, apologies, I just have one or two questions. This is Examiner Davis. So, as Ms. Irwin's questions have suggested, there are some WRC decisions out there that indicate that length of service is potentially a consideration, particularly as to discharge decisions. I think you've testified that you didn't consider that. Does it follow that it's your testimony that I don't care if they're a 1 year employee or a 28-year employee, under these circumstances, discharge is going to be the penalty, all other things being equal?
Yeah, thank you for the opportunity to clarify that. I think, I was being specific to this very concrete in answering that question, that there was there was like it when I say cut and dry again, I kind of want to retract what I said on that. I want to be more specific that it seemed like a pretty easy fact pattern for assigning discipline and termination. We always consider the holistic facts of a case. So, like, seniority does matter. And again, it depends on the fact pattern. We also, I know Ms. Irwin asked this, and I'd like to articulate this more clearly, that all of it matters. Like when it comes to FMLA, we have to look at the information that I have to look at it. And so it's not that in Ms. Schultz's case that there was a decision like the policies, the policies, the policy. There were some things that have come up that were also taken into consideration, such as the after the fact FMLA approval. I would say some of the questions that were asked about the inclement weather. So I took all of those into consideration too. So thank you for allowing me to reframe that.
All right, thank you.
Chairman Davis, can we just ask her, how can it be about a single notification when she's stating, referring to a fact pattern? I feel like she just contradicted her previous testimony.
So I'll let the witness testify. I would understand her answer to be, this is someone who has many, many tardies, has already been given grace once, if you will, when they could have proceeded to termination. That's how I would understand the witness's answer. Am I correct, Ms. Steele?
Yes.
But throughout this this hearing, we were blocked from discussing her prior tardies, and it was only supposed to be directed at these most recent tardies, which resulted in her termination.
No, I think the point on the other tardies is there was no discipline that followed from those. To the extent there was, she could have appealed and she didn't appeal. And so they are what they are. There's no ability to go back and litigate it now.
In the I just want to reiterate in the in Attorney Makovich's opening statement, he stated this is a single notification issue.
So what's your question, Ms. Irwin?
So if Attorney Makovich is stating that their argument was that this was a single notification issue, now they are changing their entire argument.
All right, I don't understand that to be so. It's a single issue that triggered the discharge. In that sense, Attorney Makovich is absolutely correct. But obviously, the prior discipline played a significant role in the decision-making process.
Okay, it just seems that they're changing this to a termination based on performance.
Well, I don't think the record reflects that.
Okay, thank you. Then we rest.
Anything else, Attorney Makovich?
No, thank you.
All right. Thank you, ma'am, for your testimony today. You're excused, and I'd ask that you not discuss your testimony with anyone else.
Yes. Thank you.
Thank you. Any other witnesses, Attorney Makovich?
No, the department rests.
All right. Ms. Irwin, are you ready to proceed?
Yes, we would like to call Sharon Harder, please.
All right. Is she in the waiting room? Do you know? I see her. I will admit her. So, Ms. Harder, this is Peter Davis. I'm the examiner in this matter. I think you're being called as a witness potentially. If you would turn on your microphone and turn on your camera if you're joining us online, and then I will swear you in as a witness.
Hello.
Very good. Thank you for joining us.
You're
If you'd
welcome.
raise your right hand and swear or affirm that you're going to testify truthfully today.
Yes, I will testify truthfully today.
Thank you. Go ahead, Ms. Irwin.
Thank you. Ms. Harder, how long have you been employed with the respondent?
Well, I'm no longer employed by the state of Wisconsin. I'm now in retirement status. But at this point, I was in my role as the deputy director for 7 years.
7 years. And what were your how long were you an employee for the respondent before you retired?
I was an employee for the state of Wisconsin for 32 and a half years.
Okay. And what positions did you hold in that time?
I held the position of social worker, institution unit supervisor, and deputy director.
Okay. Did you receive any information from any members of the respondent's legal counsel regarding this hearing?
No,
Since being served with your subpoena to appear today, have you communicated with any employees of the respondent regarding this hearing?
I have communicated with Director DeHaan.
Can you please share with us what those conversations involved?
Well, we just today I've just been asking, do you know the status? Because I've been sitting here, and then prior to that, I just said I'm assuming this is regarding the termination with Lori Schultz, and she assumed that as well.
What would make you assume that?
What would make me assume that? Because
Yes.
I understand, I knew before I had left that Lori was appealing the termination.
Okay. How did your WRC position as deputy director, how did that intersect with the appellant in the performance of her job duties?
Well, I did not have day-to-day contact with Lori. I supervised her supervisor. And so the majority of information I knew about Lori was through the discipline process as that was ongoing.
Did you ever have any personal conversations with Lori regarding her serious medical condition?
I did not have extensive conversations with Lori about her specific medical situation. She shared with me that she was experiencing some medical conditions, but that was the extent of it.
And when did that conversation take place?
I can't say that exactly. I don't have my old calendars or notes from that conversation. I believe it was sometime in the fall.
Of 2025?
Correct, 2025.
Do you have have you ever received any training regarding FMLA rights for employees?
I'm going to object to this line of questioning, as again, this is not a case about the department, whether or not the department is appropriately instructing her, Ms. Schultz, how to apply for FMLA.
Chairman Davis, that wasn't the policy that we introduced.
So again, you're asserting FMLA matters here. They say it doesn't. So I think you've made your case in that regard. And whether this witness did or didn't instruct anybody about anything, this does not matter.
Okay, thank you. Ms. Harder, were you a decision maker on issues related to Lori Schultz?
No,
Were you involved in any meetings pertaining to the decisions whether or not to terminate her?
yes.
Can you please describe what those meetings involved? What was said at those meetings?
So, we had just discussed that there was, repeat situations of Lori reporting to work late. And we just followed the progressive discipline process. There wasn't a lot to discuss. The decisions were based on objective data.
So objective data overrode FMLA? rights or
At that
protection?
time, FMLA was not in discussion. At the time that this was pending, Lori was, I don't know if she had FMLA at that time, but it was not something that was being considered as a mitigator.
So in these meetings, you weren't aware of whether or not she had FMLA?
No, I was not. But regardless of the FMLA, the expectation was that she was reporting to work on time.
In those meetings, was her EIR packet, I believe it was called by Ginger Steele, was that reviewed by all of you in the meeting?
That was not reviewed by myself. That was not part of my main role as the deputy director. So I did not, I mean, I don't recall reading that specifically, but, you know, we did just consider the fact that this happened repeatedly.
What was your role in that meeting if you were not reviewing the information that was gathered and during that investigation, like her mitigating circumstances? Why would you not have reviewed those while making your decision?
Those would have been reviewed. That is more the role of the director and the human resources director. Okay, my role was more, that was not my primary role at WRC.
Okay, so who decide, does everyone take a vote in these meetings?
I don't know specifically what meetings you're referring to, but we had I would say on a daily basis, we would have discussions about any potential personnel issues that were pending.
So do you recall discussing Daniel Kraus?
I do not.
Do you recall discussing Dylan Coons?
Yes.
What do you recall regarding his attendance issues?
Well, I don't know that that's appropriate for me to respond to, as it's a separate employee issue. So I don't know that I should be responding to that.
Was it related to tardies?
Was Dylan's related to tardies?
Yes.
Again, I don't know that that's my response, that I should be responding to another employee's human resource and discipline issues.
It's not privileged information though.
So let me jump in here. So Ms. Irwin, you know, what's your argument as to this gentleman? Did he get terminated or he
No,
didn't
he
get
did
terminated?
not.
Okay. And is he comparable to Ms. Schultz? He had the same number of tardies, got a 5-day, repeated 5-day?
That's what we are attempting to reveal here, because it's known that he had excessive absences and attendance issues, and it's similar enough to make a comparison. And I would like to emphasize that it appears that this witness has information that she does not want to provide that may support the appellant's case.
So let me say two things. I don't understand that to be the witness's testimony so far. She's wondering whether it's anybody else's business, what's going on with that gentleman.
Yeah.
I assume there are documents, Ms. Irwin, that would show what did or didn't happen to this gentleman, right? That you've got records that would show how often he was tardy, how often he was absent, what happened to his discipline. Do you have those?
We requested those and they never sent them.
And so what do you think they show?
They show that and the appellant is aware of him having absence issues, tardies, arriving and leaving. And the appellant was at work when these things occur.
I have to object to the statement of having requested those those documents.
Those were requested from HR director. And appellant witnessed this firsthand.
Well, okay. I want to make it. I want to make it clear that that there was a discovery request that was made to me past the discovery deadline, and making the discovery request through me is the appropriate avenue for for any discovery requests, and the discovery request did not include any. Did not specify Dylan Coons.
So what about that?
The appellant requested this information before this hearing was set and before discovery. She requested those through open records and has not received those.
All right, so I'm really not inclined to hold you or her accountable for all the niceties of this, but clearly I know you have gone through this before. Discovery is the way in which you make those requests, not open records. You became her representative. That's something you could have, should have asked through the discovery process. I mean, you didn't, even under what I gather was a late discovery request. So I'm going to allow you to pursue the question of what this gentleman did or didn't do. It's not clear to me that he's necessarily a comparator in that he wasn't. Well, I just don't know yet. So jury's out on whether he is a comparator or not, but you can proceed at this point at least to ask the witnesses questions.
Thank you. So Ms. Harder, what knowledge do you have of Dylan Coons' attendance history?
So I can't answer specifically. Again, I don't have that information in front of me. There were some attendance issues. There were some additional performance issues with this employee. And again, he went through the progressive discipline process, and his case did not reach the level of termination through the progressive discipline process.
Did he, do you know if he was allowed any repeats of levels in the steps of progression of discipline?
Again, I want to say that I feel like this is inappropriate for me to be answering about another employee. But I will say that I believe he did have a repeat in one of the steps.
And was he discussed in your meeting with the other administrators regarding whether or not to terminate him?
Yes, there was discussion whether termination was appropriate for his situation.
Okay. What were the levels of repeated discipline for him?
Again, I can't answer that without having the file in front of me. I don't want to give misinformation. I don't know that information off the top of my head.
Okay. So you said there was attendance issues combined with work misconduct, correct?
I did not say that, no. I said with performance issues.
Okay.
I did not say work misconduct.
Okay. So there was a meeting discussing whether or not to terminate, and you all voted to not terminate him, correct?
Again, that is not an accurate portrayal of saying voted on. There is discussion. There's also consultation with the Bureau of Human Resources in central office. And so it is not a voting situation. It is more of a collaborative. discussion of what's fair and right in that individual situation.
Okay. Who ultimately makes that decision?
Of termination,
Yes.
that would be Ginger Steele.
Okay.
We have to get approval from Ginger, and she's the one who ultimately has to sign the termination.
So does the deputy director, which would have been Susan DeHaan, does she make the suggestion to Ginger Steele, I want to have this person terminated?
Okay, that is incorrect, what you just stated. Sue DeHaan is the director, and I was the deputy director. So you stated Sue was the deputy. So again, I think it's more appropriate for Ms. DeHaan to answer how she processes that type of information with central office and her supervisor. She has a supervisor that an assistant administrator before Ginger Steele, where she would have that consultation.
Ms. Harder, I'm asking you what you're aware of. So you have your meeting and you communicate, collaborate, and then is it the director who then states to Ginger Steele, we want to terminate?
I don't know that. Okay, that would be a question for Ms. DeHaan. I believe, my understanding would be that she would have gone to Holly Audley or Jesse Andrews, who's the assistant administrator and her supervisor for the initial conversation, not going, Ginger Steele would be, obviously is the administrator. And so there would be consultation with the assistant administrator prior.
So you all have your meeting. Who's at that meeting?
What meeting are you referring to?
The meeting where you discuss whether or not an employee is going to be terminated. Who is at that meeting?
I'm going to object to the relevance of this question as Ms. Harder has stated that Ginger Steele is the person who makes the disciplinary decision ultimately, and I believe that this question is not relevant to this proceeding, but is in fact an attempt to gain information for other proceedings that Ms. Irwin is engaged in.
Chairman Davis, we're trying to understand this process. It appears to be convoluted accountability with now we're getting the names of a Holly and someone else that the deputy is having a conversation with. So we're just trying to understand from this witness how this process works. Who's in this meeting?
So,
And-
so I'm going to jump in and say, I'm going to sustain the objection. Steele was the decision maker. You've had your whack at her. She's told you what she's told you. She's told you that she gets it from the institution when there's a recommendation for termination. And that, I think, is all we need to know.
Okay, thank you. We'll move on. So what did you discuss with Director DeHaan regarding the appellant?
I'm going to object to the relevance of this question.
So I think she's already asked and answered that question. It was a question of reviewing the attendance issues, and that was pretty much it.
So when you reviewed the packet, the 15807.
Remember, she said she didn't review the packet. So
Oh,
what?
that's right. That's right. Thank you,
All right.
Chairman Davis. She did
You're
not
welcome.
review the packet. As the deputy director at WRC, having had the conversation with the appellant regarding her serious health condition, why did you not inform her that she met the criteria for a reasonable accommodation under the Americans with Disability Act?
I'm going to object to the relevance of this. This is not, this is not an ADA case.
So I'm going to sustain that objection. Again, we don't know the answer. I don't at this point, but their position is it does not matter.
Did you ask for the EIR packet when you discussed the appellant's termination?
I'm going to object to the relevance of that question. Why does it matter to just cause?
Because she was involved in the decision-making process.
And for further information on my objection, Ginger Steele was the decision maker. She testified that she's the appointing authority who makes the decision on discipline, and so she's the person whose information and knowledge of the packet and the situation is the most relevant.
Is it not standard practice for the EIR packet to be reviewed by the decision makers?
So I guess you could ask that question. That's a different question.
Yeah.
I gather it's not because she didn't review it. So I guess I'll leave it at that.
Ms. Harder, why is it not standard practice for the decision makers on a termination to review the EIR packet in its entirety?
So the situations with Ms. Schultz had been ongoing. There were several individual situations. I probably did look at some of the packets. I don't believe I looked at the entire packet when it was submitted for termination. But we had just discussed, if there were any other factors that we could consider. But to answer your question, the reason is because in my role as the deputy, that wasn't my main area of responsibility. That was the human resource functions fell under the director's area of responsibility with human resources. And so I was more of a, performed more in the role of a consult versus a decision maker in that type of situation.
If you
So
were there,
that wasn't my main. I want to finish. I did not read every packet of every employee that had discipline. That was outside my purview.
if your role was as a consult, did you share your conversation you had with the appellant regarding her serious health condition?
I will say this. I did share that I had an appointment with Lori. That wasn't a secret. The majority of my conversation with Lori was not about her health condition. It was about what's going on, how can we assist you, how can we help you get to work on time, what do you need from us to address this repeated behavior of being to work tardy. It was, and I do not share her health condition. That's not mine to share. So Lori was directed what to do, where to go with that information if she needed additional assistance.
What did you direct her to do in that meeting?
I'm going to object to further questioning about this because, again, this appears to be a line of questioning about ADA matters, which, again, those are other cases that Ms. Irwin is pursuing. This hearing isn't for a fishing expedition for information about other matters. This is about the just cause question.
Chairman Davis, we still don't know who's responsible for adhering to protocols. She hasn't answered that, so that's what we're moving towards.
So I think we've been down this road already. I don't believe the protocols are relevant, right? The employer said that's not part of our picture. If it turns out you're right that they were obligated to do so, you'll likely win the case,
Yes.
right? So that's all we need to know.
Are we able to, because we have brought up that it is policy that the employees, if they become aware of an employee with a serious health condition, to inform them of the FMLA availability. So can we proceed with her answering the question as to what she directed the appellant to do in the meeting she had with her?
I'm going to object to that line of questioning for the same reason that it appears to be a fishing expedition for other matters. Number one, and number two, the fact that Ms. Irwin has, in the record, on multiple times requested FMLA and has had it in place. It's whether or not Ms. Harder advised her on how to request FMLA is not relevant.
Can I make a note that you just called me?
So I'm gonna,
sorry, Ms. Schultz. I apologize.
Yeah. So I'm going to sustain the objection. Does not matter. FMLA was in place for these absences. The employer concluded it did not matter. So that's all we need to know.
Okay, Chairman Davis, this witness just said that she was talking with Lori about how to help her. Can I proceed asking her whether or not she provided her with information on reasonable accommodations based on ADA?
I'm objecting to that for the same reason.
I'm going to sustain the objection.
Okay, thank you. Can we ask what specifically did you direct the appellant to do in that meeting?
So I understand the witness to say that she had some suggestions attempting to help Ms. Schultz as to how to deal with this chronic tardiness problem that she has. And if we stay away from ADA issues or FMLA issues, you can ask her that question.
Okay. What did you direct the appellant?
We're not talking direct, right? Suggest, as I understand it.
Oh, suggest. What did you suggest? Can you give me one for example?
So I had asked, this was, I'm going to describe it as more of a casual conversation. Lori did come down to my office to meet with me at her request. We probably met for 15 or 20 minutes, if I recall. It was not a lengthy conversation. And she was concerned about the potential of losing her job. And so we talked about what strategies that she's been using to try and get to work on time. She also talked to me about the fact that her supervisor and colleagues have also been trying to guide her and assist her to getting to work on time. And that was kind of the gist of it. I mean, we didn't speak in any length about any sort of serious health condition. I do recall that she shared something with me. And again, I did guide her toward human resources if that was something that she needed assistance with. But we were very late in the progressive discipline at the time that Lori and I met. It was a serious situation at that point, and there needed to be a remedy to the continued pattern of being late for work.
Were you aware at WRC of there being any type of stigma attached to employees who used FMLA.
Again, I'm going to object to this one. It's not about the just cause here is not about stigma. It's about whether, the question is about whether just cause existed to issue discipline for repeated tardiness.
So, Ms. Irwin, is your part of your theory she was not fired for being tardy multiple times? She was fired for using FMLA. Is that your theory?
Yes.
All right, that's fine. You can ask, I'll direct the witness to answer the question.
Can you ask the question again, please?
Are you aware of there being a stigma at WRC against staff who have FMLA?
I don't think there are situations, yes, where there is some people that will vocalize their concerns about people using FMLA. I don't know that it's widespread, and it's certainly not every employee, and it's certainly not the administration.
What occurs when like you in your position as deputy director, when you become aware of an employee who is vocalizing, would it be considered harassment if they are disparaging an employee that has FMLA because they're using their FMLA?
I mean, at this point, I'm going to object to further questioning. She stated that there are people who vocalize concerns, but it's not the administration. And any response to non-administrative personnel vocalizing concerns, I believe, is not relevant to this. If there is a retaliation claim, it's going to depend on the decision makers being the ones who are acting based on employees taking FMLA.
So I'm going to sustain that objection. I agree with Attorney Makovic.
Okay, can we bring up Exhibit A36, Bates number 108?
Sorry, could you say that again?
Exhibit A36 and its Bates stamp is 108.
36. All right. So I am going to share this. I am also going to object to questioning about this because this refers directly to the other to one of the most recent objections that I made. Unless there is a showing that Benjamin Bricko is involved in issuing the discipline, I believe that the ruling was already that that's not any disparaging comments he made is not relevant to the proceeding here.
Chairman Davis, this speaks to the culture and mindset of the people who in this case Deputy Director Harder managed.
So the point made by Attorney Makovic is, and the testimony of the witness thus far is, whatever those issues are below, the key question is, do the decision makers have that same view? And thus far, there is no evidence whatsoever that they do. No testimony from Ms. Steele that played any role. So I'm sustaining Attorney Makovic's objection.
Okay, so we're not able to discuss that exhibit then?
Correct.
Okay. Are you aware of policies being changed at WRC without authorization?
I'm going to object to the relevance of this question unless there is an allegation or some offer of proof that the attendance policy was changed in a manner that disadvantaged Ms. Schultz. I don't think it's relevant.
There was a policy change. I don't know if Ms. Harder is aware of it, that restricted doctor's slips from being able to be applied to absences until employees reached the threshold approaching discipline for those absences.
So I'm going to
There
sustain
have been policy changes.
So I'm going to sustain the objection. That doesn't sound at all relevant to the question of tardy policies.
Okay. What did you mean, Ms. Harder, when you stated that you were late in progressive discipline? Was there termination catch-up because the respondent was late taking care of the progressive discipline for the appellant?
What I meant by late in the progression, and again, I don't have the dates or any file information in front of me, but Lori had been disciplined a few times at that stage. And so I don't remember where in the progression we were at, but it was clear that things were serious and that there needed to be some improvement. And that's what we were talking about.
Would her serious medical condition not be considered serious enough to consider?
That would not be that would not be something that would be in my area of responsibility to consider. But again, people have to come to work on time, and we can't run the organization without people showing up to work.
So are you aware of staff who were put on administrative leave? Those positions would be accommodated, wouldn't they, for say an arrest?
So Ms.
I'm
Irwin,
going to object.
we've been down this path.
Okay.
I've already
thank
said
you.
we're not going there,
Forward.
so please honor my prior rulings.
Okay. After, Ms. Harder, after having the meeting with the appellant, were there times when you would arrive on her assigned unit and you would acknowledge the staff that she was working with, but you would not acknowledge her?
Absolutely not. I don't have any situations where I had no reason to have ill will or a poor working relationship with Lori. That was not the case at all.
So what were you, can you just describe what you meant by late progressive discipline? Because
All right.
it's,
I'm going to
So Ms.
object. That's
Irwin,
asked and answered.
we've already been there, right? She doesn't specifically remember. She'd already been disciplined. It was serious. She was there knowing her job was on the line.
okay. Then we will rest.
Attorney Makovic, any questions for this witness?
No, thank you for being here, Ms. Harder.
All right. Thank you, Ms. Harder. You are free to go. I'd ask you not to talk about your testimony with anyone else today.
I will do that. Thank you.
Thank you. Other witnesses, Ms. Irwin.
Yes, if we can please call Director Susan DeHaan, please.
All right, Ms. DeHaan, this is Peter Davis. I'm the examiner in this matter. Thank you for joining us and being patient as you waited. You are going to be a witness in this matter, so I'd ask you to turn on your mic and turn on your camera as well, and then I will swear you in as a witness.
Okay.
Thank you much. Can you swear or affirm that the testimony you'll give today will be the truth?
Yes.
Thank you. Go ahead, Ms. Irwin.
Thank you. Ms. DeHaan, how long have you been employed by the respondent?
I've been employed by the state of Wisconsin for approximately 32 years.
Okay. Since being notified to appear today, have you communicated with any employees of the respondent regarding this hearing?
Yes.
Who have you communicated with?
Well, there has been some requests for records through the HR director, which I assume is relevant to this. And so whatever records have been requested for either this or other situations, I have been providing records.
Okay. Have you communicated with any employees regarding this hearing?
Well,
Or
yes,
former employees?
certainly I had to let people know that I would be in a hearing today. So my deputy knows I'm in a hearing today. Of course, I think one of my employees has been called as a witness, so he needed to let me know that scheduling wise, he was not going to be available.
Did you have any conversations with former Deputy Director Sharon Harder regarding this hearing?
She did let me know that she was subpoenaed. Yes.
Okay. Was that the extent of your conversation with her?
Yes, pretty much. I mean, I did remind her that that Lori had been terminated. So
You informed her of what the hearing was going to be about?
yes, and then I did let the HR director know that she had been subpoenaed, so that there was an awareness of that. And of course, we had talked extensively about the situation prior to any decision being made earlier this year. So we were already familiar with that.
Can you please share what that extensive conversation involved?
As a decision maker, we certainly communicate about all staff who are subject to discipline. And so there is a lot of consideration and careful thought that goes into every discipline decision.
Okay, when you said careful thought, did Sharon Harder inform you of the meeting she had with the appellant regarding
Yes.
the appellant's concerns about getting terminated?
Well, it's our practice regularly when somebody is at a 5-day suspension to have the supervisor and sometimes even the HR director or the deputy reach out to that staff member to ensure that they recognize that their job may be in jeopardy because the next step in the progression is termination. So we typically discuss that and create a plan to reach out to this employee to find out what they need to be successful. And so, yes, that was a planned conversation that we had concern for Ms. Schultz and her job. And so, yes, she did.
So what was the plan that was created for the appellant to be successful?
Well, we don't create plans specifically, we offer opportunities. So I'm a pretty staunch advocate and protector of FMLA. As a former HR director, I recognize it's a federal and state protected status, and it's one of the ways that our staff can really get their needs met when they have a serious health condition. So early on in the progression of discipline, I had made sure that Lori was aware of the availability of FMLA. That's often a an option that we exercise just to ensure that our staff are aware of their options to getting their needs met, because in my opinion, that's critical.
When did you reach out to the appellant?
So I personally did not. I know that the HR director reached out as soon as that showed up in a disciplinary investigation summary, in which Lori said, she referenced some type of medical. And so early on in the process of the progressive discipline, that was a reach that the HR director made to ensure that she was aware of the availability of that. And I believe it was multiple times thereafter that her supervisor or others had reached out to her.
How do you know that HR reached out to her?
I'm going
Because I
to
wouldn't-
object to further lines of questioning about FMLA. It's been established at this point that Ms. Schultz was advised about taking FMLA, and I don't believe that it's relevant any further to this case.
So I'm going to sustain that objection. The record speaks for itself. She got it. There's been testimony that people told her about it. She'll testify about whatever did or didn't happen. I think that's all we need.
Just concerned about where the proof is that the appellant was advised about taking FMLA.
Well, you just have the testimony, right? So you can argue that didn't happen. Your client may say they never told me anything, and I'll have to sort that out. But again, fundamentally, the employer's position is it does not matter in this case, whether they did or whether they didn't. She got it. Okay. It was in place when the tardies occurred. And from their perspective, it did not matter. And I think we've gone through this 4 or 5 times.
Thank you. Who is the decision maker regarding terminations?
The administrator of the Division of Care and Treatment Services.
Do you give her a recommendation?
Yes.
How do you come to that recommendation?
Well, in all discipline, I review the merits of the issues presented, the totality of all of the factors. So there's a lot of considerations. As I originally was identifying, there's careful consideration of the evidence that's presented, any mitigating or extenuating circumstances, the impact on the facility and the inmates who live here and the staff who work here. There's consideration of what past corrective action has been taken and whether that has been successful, whether it's a repeated issue, whether it's egregious. We also, of course, consider the work rules, the DHS discipline policy. So that and more is all that goes into those considerations and ultimately decisions made.
So
we also look at comparators, what happens to people in similar situations. So other attendance disciplines would also be considered. And primarily in a lot of the attendance, we really look at the progression.
Well, who were the comparators in the appellant's situation?
I don't have any specific people that were compared to. What we compared it to other people who have progressive and uncorrected attendance violations that continue. That's what we would have compared it to.
Are you familiar with any other employees who have attendance, repeated attendance issues that were given discretion and not terminated?
Not off the top of my head. No, I'm sorry, I don't.
Sharon Harder had testified that Dylan Coons, that was discussed in a meeting and it was decided not to terminate him. How was his case different from the appellant's?
So Ms. Irwin, I don't think that's what the witness testified to. So to the extent I'm correct about that, you're mischaracterizing her testimony. So I think you asked about that gentleman. She answered some questions, but I don't think there was ever a question about recommending his termination or not. You're welcome to ask this witness that, but please don't mischaracterize prior testimony.
Okay, thank you. Are you aware of any meeting that you were involved in where Dylan Coons's absence and attendance issues were discussed?
So my immediate recollection is that there were other issues that were brought forward that we were making decisions about. And that Dylan has received progressive discipline as well.
Was it similar to the appellant?
No, because there were other factors involved.
Did he have tardies?
I honestly can't recall. I don't know.
Okay.
I don't think I've ever had a person that had consecutive tardies like this that I can recall in the immediate past.
Wouldn't that be kind of raise a red flag then, that when the appellant is expressing that she has a serious health condition, wouldn't that be an application of policy and FMLA rights that would be considered?
I'm going to object to that question. She's already talked about she's already talked about offering Ms. Schultz the opportunity, or the opportunity, or Ms. Schultz having the opportunity to request FMLA, and the fact that this was something that was reviewed and recommended.
And this witness just stated that she's not aware of anyone else that has had tardies like this, and
which goes to the question of comparative discipline.
And this is the second witness that stated that there are no comparators. So this is a unique situation. So I feel that it's important to find out why application of FMLA would not come into play.
So you've already addressed this with the ultimate decision maker, Ms. Steele. She said what she said, and she's the one who made the call. So I think the record is clear as to they were aware of it, and they concluded they needed Ms. Schultz to show up for work. And she wasn't, and that's why they terminated her employment.
Are you aware of any stigmas attached to staff at WRC who use FMLA?
I do think that FMLA at large, not just at WRC, can be stigmatizing to some people. And that's why I fight hard to maintain the legitimacy of it, to make sure it's offered when appropriate. And when it's utilized appropriate, I'm 100% in support of it. But I will also add that I can only offer it. The employee does have to work within those parameters, and it is a leave status. It doesn't apply to not showing up for work. And as a employing agent, I feel that it makes it harder for other people to utilize FMLA when the organization is impacted and individuals who are working are forced to stay behind because people don't show up for work or don't call in. And it's also a safety and security issue for our operations. So if my recollection is correct, there were 12 tardies in almost a year's period, 8 of them in 1 year.
Chairman, Davis, I want to object, because we don't know if any of these, suggestions to, the appellant ever even happened. She's talking about safety. She's suggesting that safety was an issue. So I want to object to this testimony and move forward with our questions.
So I'm not going to strike the testimony. I think it reaffirms what I will tell you that I firmly believe. In effect, they're running a prison. There are safety issues. If people don't show up for work, other people are held over for overtime, on and on and on. So I've been through this a few times. I get their point. I believe their point. So her testimony is going to stand. I don't know if you have a pending question that she has not answered.
Yes. Are
What
you
is-
aware, sorry, Chairman Davis.
Go ahead.
Okay. Ms. Dehan, are you aware that, the tardies involved time spans of 3 minutes, 14 minutes? Are you aware of that?
Yes.
And are you aware of the appellant calling before, calling when she realized that she was going to be late?
Not consistently is my recollection.
But you do recall her, it being noted that she called ahead of time?
Once or twice, I think, not every time.
Okay. Can we bring up, I believe it was an R4 exhibit, Attorney Makovic, which was the EIR?
Sure was.
Thank you. Could we bring that up and could we go to those tardy slips again?
So, Ms. Irwin, we've reviewed the tardy slips. They're in the record. I know what they say or don't say. Some
Okay.
of them show she called in, some of them she didn't. She can
Yep.
testify if she wants that she called in every time. And I will just say that then there's going to have to be some explanation from your perspective on why it wasn't recorded.
Yes, exactly. So we just got this witness admitting that she was aware that the appellant had called in ahead of time. What was the term you used? Several times?
Once or twice.
No.
Once or twice?
And sometimes those were like at shift. It wasn't, there was irregular periods. So it still was problematic for us. We asked for 90 minutes for a reason so that we can assemble a shift and relieve people. So a minute or two before shift, 5 minutes before shift, we're still scrambling. So I don't have it memorized, so I don't know the exact number, but I know that it was enough to be disruptive. I think the sheer volume was the problem.
And you were aware that that there was a gap from 2023 to 2025 where the appellant who had the this lifelong condition where she had no attendance issues. Are you aware of that?
Well, I'm not aware of her lifelong condition, and nor have I gone back and studied that gap. But what I'm looking at is in a progressive discipline sense, this is where we landed.
Did you review the EIR packet before you made your recommendation to Ginger Steele?
At this
Yes.
point, I'm going to object to further questioning of Ms. Dehan as to the decision-making process, as I believe it is duplicative, because at this point it has been established that recommendations were made. Ms. Steele testified that she was the ultimate decision maker, and we can have 14 people testify about what recommendations were made or people wanted to recommend to Ms. Steele, but ultimately the decision lies with her. We've now had two witnesses both testifying about recommendations to Ms. Steele.
So, Ms. Irwin, I'm inclined to agree, right? She made the recommendation. She's made it clear what it was based on. Multiple tardies, not calling in at all, or not calling in on time. And that's where we are.
Okay, thank you. We'll move forward. Ms. DeHaan, are you aware of when the appellant was working on her assigned housing unit, if a coworker had a medical appointment and had to leave, are you aware that a replacement would not be provided?
There are
I'm going to
times that-
object to the relevance of that question.
She was getting ready to answer. This witness just stated how safety was jeopardized when the appellant would arrive 3 minutes or 14 minutes late. This witness was just about to answer.
So the fact she was just about to answer is irrelevant, right?
Yeah.
So I'm sure it's the case. Sometimes they replace, sometimes they don't. So it goes. All right. The fact that they don't
Okay.
sometimes doesn't mean anything as to this case, right? Generically, it's a safety issue. I'm buying that. I'm telling you that. So we should move on.
Okay, thank you. So did you review the for the pre-disciplinary hearing and the mitigating circumstances that were shared by the appellant? Did you review those
I would
prior
like to renew my objection to further questioning on the recommendations of discipline, as again, recommendations were made to Ms. Steele, who was the appointing authority who made the ultimate decision.
All right. So I'm going to sustain the objection generally, but if your question is, did she review a specific document? That's all we're talking about. You can ask that question.
Yes, I asked if you had reviewed in the EIR packet the pre-disciplinary meeting where the appellant provided her mitigating circumstances. Did you review that documentation?
Yes, I'm sure I did.
Do you recall any details in her mitigating circumstances that influenced your decision?
No, I don't recall anything about that specifically at this time. I do know that at the time of her call-in, she did not have FMLA approved, and I do believe she requested it thereafter.
And are you aware that her FMLA was backdated to cover the most recent tardy?
I'm going to object to the relevance of that question.
So, the record speaks for itself. We know it was backdated to cover it. We also know it's true that when she called in, she did not say, I'm calling in to use FMLA.
And can we bring up A1 exhibit, please? If we can scroll down to the and right here do you see where it states this form is to cover dates of incapacitation from 1/1/26 to 12/31/26.
I'm going to object to this question. We've gone over this
I
So,
was just,
many
Ms. Irwin-
times.
So, Ms. Irwin, I agree. We know what the record says. It
if
says
we
what
could
it
just have
says.
Ms. DeHaan recognize the date of 1/1/26, and then if we can move to exhibit A2.
I want to
Page
make an objection there
5.
because there's a bunch of things being said there, kind of in the middle, and I don't want it to be acknowledged by anyone that anything has been. I know part of this is not about this case, so I don't want a record to be that could even be interpreted as Ms. DeHaan approving or acknowledging something that she did not answer because of my objection before we move on to whatever the next thing is. Can we get just a ruling on that objection then, Examiner Davis, please?
So in effect, I ruled we're not going to talk about A1. It is what it is. It says what it says. We know that Ms. Steele was aware of it. End of story. I don't know what A2 is. We have to get to
Okay, if
A2 and
we
I'll
could
then
move-
rule.
Yeah, Ms. DeHaan is in this email. And this is,
Yeah. So
if we can scroll to where, down to, now here we see that, Ms. DeHaan, were you included in this email from the FMLA coordinator at WRC?
I'm going to object to the record. The record speaks for itself, as Ms. DeHaan's email is right there.
all right. So I think that's a fair objection, Ms. Irwin. It says what it says. Again, we know their position is this does not cover tardy. So I think I'd ask you to move on.
Okay. So did you, what do you recall about the conversation that you had with Sharon Harder regarding the appellant's concerns about losing her job?
I'm going to object to the relevance of that question, as we've had multiple questions about the matter, and Ms. DeHaan has stated that she reviewed the materials and made her recommendation to Ms. Steele, who again is the appointing authority who made the decision on discipline.
So, Ms. Irwin, I'm gathering your client is going to say that conversation never happened. That's fine if she says that, all right? I will tell you that I'll be skeptical if she says that conversation never happened, but so she can testify. And I'll also tell you that if I conclude she's not being truthful when she says that, that's not going to be a positive for the outcome of this case. Makes sense to me.
Davis,
Go ahead.
the conversation the appellant had with Sharon Harder, the deputy director, did happen. So I am asking what this witness recalls regarding, because Sharon Harder testified that she informed Susan DeHaan of her meeting with the appellant. So I feel it is pertinent that we are able to ask this witness what she recalls was relayed to her.
So I'm going to sustain the objection. Your witness can testify as to what happened, and it'll go wherever it goes.
Okay. Then we will rest with this witness.
All right, Attorney Makovic, do you have any questions for the witness?
I do not. Thank you for being here, Ms. DeHaan.
All right, Ms. DeHaan, you are excused as a witness. I'd direct you to log off and not talk to any other witnesses about your testimony today. Thank you very much.
Thank you.
Other witnesses, Ms. Irwin.
Mike Preby, please.
Is he one of our witnesses?
Yes, you issued him a letter of appearance.
All right, I believe I see him there. So, Mr. Preby, thank you for joining us. If you could turn on your mic and turn on your camera, and I'll swear you in as a witness. Thank you, sir. If you would raise your right hand and swear or affirm that you're going to testify truthfully today.
I will, yes.
Thank you. Go ahead, Ms. Irwin.
Thank you. How long have you been employed with the respondent?
18 years.
What positions have you held during your employment with the respondent?
I was initially a PCT and then operations PCS, a second shift commander, the first shift commander, and my current position as administrative captain.
So what are your duties as the administrative captain?
Scheduling, hiring, discipline, myriad of things, supervision of the PCTs, PCSs.
So in this case, you know that we are focusing on attendance. Are you aware of any other staff who have had attendance issues similar to the appellant?
Staff being tardy or termination or
Yes, tardies.
yeah, staff are tardy. Yes, I'm aware of that.
Yep. How are you aware of Daniel Kraus having a history of tardies?
I am aware of Daniel Krause. I didn't know that there was a tardy issue with him.
Do you recall how many tardies
For who?
for Daniel Kraus?
I'm aware of Daniel Krause. I'm not aware that he had a attendance problem with regarding to being tardy.
So he was never under a formal investigation for tardies?
I don't recall whether he was or not.
What if we look at Exhibit R4, please?
So, Mr. Preby, Mr. Attorney Makovic is going to share that exhibit on the
Okay.
screen, so we'll
Thank
see it.
you.
Thank you.
Okay.
So if we
see
can
it.
scroll down, Mr. Preby's name is in. So can you explain why your name is in this area of name of person reporting allegation?
Because I filled out the 15807, the form that we're looking at.
Okay. Do you fill out all 15807s on staff who are tardy?
I filled out many of them, but no, not all of them.
Were you aware that the appellant had called in when she realized she was going to be late and those were not documented on the tardy slips.
I am not aware of that. That's not information I had, no.
Were you involved in any part of the review process after the investigation was completed?
I am in a advisory position, and it's reviewed weekly, so I have some knowledge of that, yes.
Okay, so do you review investigations as they're being conducted?
Not necessarily. There are times I'm asked to look at things. Um, it's not a uncommon request for me to look at that. Looking at investigations.
When you are, so would you say you assign investigations?
I don't assign investigations.
So you just start the process with filling out the original 15807A?
So, if I may explain the process,
Yes.
there is when we're talking attendance, there's notifications via email and then a paper copy of the notification of a work rule attendance violation. I get notifications via email and I get the hard copy. And if I notice that there was not anything forwarded to HR, typically I'm copied in on that. I will fill out the 15807 and send it to HR. I do not initiate the investigations. That is an HR function. I just only call attention that once a threshold is achieved. Now, for a tardy violation, the employees afforded 3 tardies before it actually is a violation of a work rule. So that's tracked. I don't manage that, but I watch that as well. And on the 4th occasion, that's when 15807 would be initiated by myself or one of the other schedulers.
So you stated that you don't manage them, but the tardies, but you track them. Is that how you worded it?
I believe that's what I said because I track it. We have an OA that actually logs all this in the employee's leave tracker. I get a copy of I'm one of the people that get a copy of the notification. Other goes to payroll, the supervisor, and then the employee themselves.
Can we bring up Exhibit A3, please? Page 7. So if we can scroll down just a bit. So do you see here, what are the times that the appellant was late
So
on these tardies?
what I'm seeing recorded on January 8th, it appears that she was 2 hours late. On January 16th, 3 minutes. February 3rd, 10 minutes. And then on February 20th, 14 minutes.
Okay, can we scroll down to the next page, please? Did you review this tracking form of the appellant?
Yes.
So can you explain why there would be FMLA ?
I don't make that entry. I don't know.
Okay. So when you see FMLA documented on a form like this, does it not raise concern for you that this employee might have a serious health condition that may need accommodations?
I'm going to object to further line of questioning here because, again, we've gone over the FMLA thing a lot. And I believe it misstates, to the extent that this is being raised for the tardy, I believe it misstates what's in the evidence because of the way that the chart lines up. It's a little bit hard to read over 2 pages. First off, and second off, renewing an objection. I feel like I've objected 100 times to questions about the process for Ms. Schultz to apply for FMLA.
So I'm going to sustain the objection, Ms. Irwin.
Okay. When you are starting a 15807 packet for an employee, are you basing that decision on policies and procedures that are in place?
Yes, that and the allegation of the violation.
Are you aware of discretion that's used with employees when they are tardy from work where supervisors may not document those incidents?
When supervisors, could you clarify what you're asking, please?
Yes. Are there certain circumstances where if an employee is, say, 2 minutes late, that it may not get documented?
No, not to my knowledge. I can't say because I'm not doing it, but my expectations of the scheduling supervisors are to record everything. They do not have the authorization or the discretion to absolve the employee of that. It's only the appointed authority, which is the director. In certain situations, I will notify the director when there are many staff that have an issue reporting to work, and it's at her discretion to make an accommodation at that point.
So you've had situations where a lot of staff were tardy and the director has made accommodations?
Yes, that's correct.
Never mind.
Can you elaborate on that, please? What were the circumstances of a lot of staff being tardy and then the director making an accommodation?
Well, we've had major accidents on Highway 41 that have caused backups, and a significant number of staff have been late. We've had trains. The proximity of WRC, there is a train track that interferes with one of the main entryways or the routes to WRC. There have been times where the train has been delayed or stuck on the track for 30 plus minutes. Situations like that. Inclement weather is a different situation where the appointing authority has the discretion to make those accommodations. I also give input in that.
Was there a stretch of time where tardies due to the train were allowed?
What do you mean allowed?
I'm going to object to just answered the question about accommodations for a train crossing.
So I think he's answered the question, Ms. Irwin.
Was there ever an email notifying staff that tardies due to the train would no longer be considered with discretion.
I'm going to object to the further relevance of this this question, as those are referring to singular events, and in none of these does there appear to be a singular. In none of these is there evidence that there is a singular event causing multiple staff to be tardy.
So I'm going to sustain the objection, Ms. Irwin.
Okay. So when there's a group of staff that are tardy, are there safety concerns? How are those staff covered in those situations?
I'm going to object to the relevance of that question to Ms. Schultz, to the just cause question of Ms. Schultz's discipline.
So I'm going to sustain the objection. Ms. Irwin, I've already made clear, I'm aware it's a prison, basically. There are inherent safety concerns. Somebody's stuck behind a train and can't get to work. That's beyond their control, right?
Yes, thank you. Then I would say we can rest with this witness.
Any questions, Attorney Makovic, for this witness?
No, thank you, Mr. Prevey. Thank you for being here.
Thank you, Mr. Prevey, for waiting on us today. You are excused as a witness. I'd ask you to log off and not to talk about your testimony with anyone else.
Okay, thank you.
Thank you much. Have a good one. Other witnesses, Ms. Irwin.
Yes, can we take a short break before the appellant testifies?
Any objection to that, Attorney Makovic?
No, I was about to ask for a short break myself, so I appreciate it.
All right, very good. What, 5 minutes? Does that work?
Could we do a little bit longer, maybe 15?
Let's go with 10.
Okay.
All right.
All right, thank you.
Thank you, everybody. Yep.
to get to this point, we're good in all areas.
Excuse me. Peter Davis, I'm back. Obviously, Attorney Makovic is back.
Because I had my microphone up on my head so you couldn't hear me. Yeah, I stated.
Right. No. All right, are we ready for Ms. Schultz's testimony?
Yes.
All right, Ms. Schultz, I'd ask you to raise your right hand and swear or affirm you're going to testify truthfully today.
Yes.
Thank you. Go ahead, Ms. Irwin.
Okay, thank you. Is there anything that you are concerned about right now as we get started?
I am a bit leery to discuss what happened in a meeting that I was in because basically I was called a potential liar already, and I don't feel comfortable.
So I assume this is the meeting with the, I'll call it assistant director.
Deputy director, yep.
Right. Yeah. So my comment was to the question of whether a meeting happened at all. All right. And if you were going to testify that the meeting never happened, then I would have a direct conflict between you and the assistant director. And I would have to sort out who is telling the truth. And my point was that if I determined you were not, that would not be a positive for the outcome of this case. I think that was my comment. So as to what did or didn't happen during the meeting, she testified as to what she said, and you're welcome to give your version of it. And I would tell you that it probably doesn't really matter. Probably is irrelevant to how this case turns out. It's perhaps relevant in the sense of the employer demonstrating that they tried to go the extra mile here, gave you an additional 5 day when they didn't have to, gave you some suggestions on how you could get to work on time. And to the extent you're going to testify that they gave you no such suggestions, that's your prerogative. And I'll have to weigh who's telling the truth in that regard.
I get that. I just don't understand why it was even mentioned. I mean, I hadn't testified. Why would you say if I'm not truthful about a meeting happening before I even gave any testimony?
Yeah, I did not say that you weren't going to be truthful. I indicated that if that was going to be your testimony, and I was wrongly assuming at that point that that was what you were going to say, that then I would be put in the predicament of deciding who was the truth teller. And I will tell you the reality is, generally speaking, the person who's been discharged has every incentive to speak in a certain way. And that is an assumption that all decision makers make when measured against what the manager has to say. So to the extent you were misinterpreting your comment, I apologize for that.
Okay. Thank you. We'll move forward. Can we start then with the meeting that you had with Deputy Director Harder? Can you please share how that who initiated that meeting, please?
I did.
And what was said in that meeting?
Can I start from the beginning? Like, I initiated that, and I contacted her based off of my direct supervisor, IUS WIT. I had asked him if I could talk to Director DeHaan, but he said I should follow the chain of command. So I reached out to Deputy Director Harder. And we set up a time to meet. And mind you, I don't think I've ever had a one-on-one, I did not ever have a one-on-one conversation with her regarding anything, even as just an employee. So I was very nervous, and so she kind of would ask me questions about my employment history with the state. And as I became comfortable, I discussed my mental health and my medical health issues, because I've had FMLA for both. And the majority, she is correct in saying that the majority of our conversation do not pertain to that. And I would have to say, in my opinion, it was because she was asking me questions, and probably to help me feel comfortable talking with her.
So what did you share with Deputy Director Harder regarding your medical serious medical issues that you were having?
I can't say verbatim what I said. I believe, and I will say that I also have difficulty remembering specifics because of my medical issue, but I remember saying specifically that I've had FMLA for mental health in the past, and I've had the FMLA in 2023-24 for the medical issue, and that I was struggling with that and with my medications for it, not controlling it. And I am on several medications, and that I've also have sleep issues related to my medical and mental health issues. And we discussed that. I was very open with her.
And did you express to her any hesitation about getting FMLA?
Yes.
What did you share with her about why you were hesitant to pursue getting FMLA certification?
At that time, I believe it was between the 2 5 days that I met with her, but I cannot say for sure. And at that time, I did have FMLA in place if that was the case. So I had discussed how I was trying to manage my chronic medical illness and mental health on my own, because when I first started at WRC, it was made known that there was a stigma against those with FMLA. And I felt almost bullied in a sense at times from certain coworkers.
Was there a time when you went to third shift and you learned of an employee keeping track of staff who use FMLA?
Yes. I wasn't made aware. I was shown by this particular staff member her duplication of we used to use Atlas system, and she would track people that called in. She worked third shift, so she would try to track people on all shifts, she told me. And I did see this, and she consistently conveyed to me her belief that many staff on FMLA abuse their FMLA.
Is there anybody else that you communicated to regarding feeling hesitant to pursue FMLA because of the stigma that was attached to it?
Definitely. I discussed it with my direct supervisor, IUS WIT, my PCS, Sam Vangsa, and of course with my coworkers, my close coworkers that worked on the unit with me.
And can you describe how your migraine symptoms genuinely prevented you from complying with the 90-minute call-in rule?
So my symptoms are, how do you, they come on, and it would include severe pain at the base of my skull neck area, and like be all the way through to behind my eyes. And I would have visual and audio visual effects that would make it worse. I would also have brain fog, which is described as not remembering. And for example, I have many times taken my morning medication and 10 minutes later, I can't remember if I took it or not. And it would, when I'm in that much pain, it is hard for me to keep track of time. And as soon as I was able to, I would realize that I'm going to be late. But there are times where I wasn't, because that day maybe my medication kicked in and I felt good enough to be able to drive safely and felt that I would be able to safely perform my job.
Did you notify your employer as soon as you possibly could?
100%, absolutely. And in the 4 cases, only one time did I not. And I was called by the ops PCS at about 4 minutes after my start time at 6 a.m. The other 3 times I called as soon as I was able to, but it was after the 90-minute time because I wasn't physically able to. And it was before 6 a.m. that I called, and I also gave them an approximation of when I would be in.
When did you realize that your FMLA could cover the late arrivals for flare-ups pertaining to your serious health condition?
When I discussed my situation and all of the last couple of years, going back to 2023 with my neurologist. And we talked about the pattern of my symptoms and how it is like a roller coaster, and you're going to have periods where I'm doing good for the period of time, and then periods where I might have one migraine for less than a day, or chronic migraine where it lasts more than 72 hours. And he and I discussed how I was having difficulty getting to work on time when I have flare-ups. And he said that he would be able to cover that. I had no idea that that is something that I could have been covered for. And that is why I waited so long. because I was trying to fix it myself. Sorry.
It's okay. Did WRC's Human Resources inform you that FMLA could only cover full shifts?
Yes, when there was a period of time.
It's okay.
I can't remember exactly if it was last year or if it was the year before. But there were times when, so my FMLA said, I need a minute. Sorry.
No apologies needed.
So let me take a drink. So I don't know if I can do it without tearing up, but
It's okay.
there were times. Can you repeat the question now? Sorry.
Did WRC Human Resources inform you
Okay.
that FMLA could only cover full shifts?
Okay. Yes. There were, I think it was maybe 2 incidents, and I could be wrong on that number, but where I talked to the ops PCS, and prior to my shift, and I cannot honestly say if it was before the 90 minutes either, that I would, if I felt better, I would come in. If my medication helped that I could drive safely and perform my job duty, I would come in, and they allowed it for, like I said, 2, maybe 3 times, for sure 2 times before I was contacted by Gina Leipold Ruby, the director of HR, saying that my FMLA only covered full shifts or full days.
So it was your neurologist that informed you that the flare-ups and parties could be covered?
Correct.
Okay.
And I just wanted to say that migraines don't have a pattern. It's just so unpredictable. And if my medication was feeling good, that I thought, well, I don't want people to have overtime because of me. And so if I could come in later, I thought that I was being helpful.
Which supervisors or administrators at WRC did you have conversations with regarding your FMLA certified serious health condition? And what did those conversations entail?
What supervisors? I think I said already, like I had discussed it with my IUS, Andrew Witt, my PCS, Sam Bangsa, and I just, as far as supervisors, and then also deputy director at the time, Sharon Harder.
And did you inform any supervisors that the stress of the possible discipline for being tardy contributed to your lack of sleep, which then would compound the migraine symptoms and duration?
Yes, absolutely, I did. I discussed that with both IUS WIT and PCS Mangsa.
Can you describe how you were informed you were going to be placed on administrative leave?
The day that I had my 4th tardy, I 100% can't remember if I was contacted. I believe I was on the phone with by Captain Preby. And he came to take me out of the institute. I was able to grab my immediate belongings. And so he came onto the unit. I want to say it was 1:30-ish, 1:45 p.m. that day, that same day of my fourth tardy. And then he walked me out to the administration building where we went to a conference room with Director DeHaan, and she informed me. Captain Preby, I don't think said much of anything, if at all. It was Director DeHaan explaining that I would be on paid administrative leave.
Can you describe how you were escorted out off the unit with were there inmates and staff who witnessed you being escorted out of the institution by Captain Preby?
Yes, the inmates on my unit, on H15, my unit, there were multiple, maybe a handful of inmates out in the day room. And then as we walked out, it was second shift that time when they come in. And so I walked past several coming in on second shift. And then of course, there's other staff coworkers in the hallway at times. And I remember seeing a few of my first shift coworkers, not direct coworkers on my unit, but on other units that were in the hall.
How did that feel as you were walked out past inmates and staff for
It was humiliating.
being tardy?
And I realized that they have to do it. And Captain Preby even said that to me as we were walking out. That's why they do it at that time. But it was humiliating because I know I'm a good worker and was valued. My IUS consistently told me that when we had conversations about my tardiness, and I have very good rapport with the inmates on my unit, and they are all well aware when they see Captain Preby that it's not good. And then, yeah.
So what was the explanation Captain Preby gave you for walking you out during cross shift when the most staff would be viewing you?
I believe he said for the safety security of the Institute, and I can't say 100% what he told me the reason was. I don't remember exactly. I just know it had to do with, they picked that time because of like staffing on the units, the people that are on the units at that time. And so that's part of it, but I don't remember 100% of what he said.
When, were there times when you were working your unit and staff would leave the unit, not return, and they were not replaced?
I'm going to object to the relevance of that question.
It was,
So Ms. Irwin, we've been down this road before, right? So
yep.
sometimes they'll replace, sometimes they won't, sometimes they can, sometimes they can't. It depends on when you leave the unit, on and on and on. I've already indicated that I'm persuaded that it's a dangerous place to work. My guess is Ms. Schultz would probably agree with that.
Yes.
Yep.
Okay, we will proceed. So how many years were you employed with the respondent?
over 27 and a half.
How many years were you a PCT at WRC?
I started in October of 2019. And then
So 7 or
till
yeah,
April 2nd of this year.
okay. So about 6, 7 years.
6.5
Okay.
ish.
Did you ever have any issues getting along with your supervisor, coworkers?
No.
How about your rapport with the inmates? Can you describe that?
I had good rapport with the inmates. They respected me, I felt, and I performed my job as the safety security first for staff and the institute and inmates being at the bottom, but then I also treated them as I should. They're human beings, and so I was fair and consistent with our policies on the unit and tried my best to do that. And I think that built good rapport with them and they respected me.
Thank you. Did your supervisor or any other staff express to you that they did not want to lose you, as in getting terminated?
Yes. Pretty much anyone that knows me said something to that effect to me.
So there were approximately how many staff would you say expressed support for you when they knew you were facing termination?
So the people I work with on the unit I consider them my good friends. And so them, and then I had made friendships when I worked on third shift with third shifters, just pretty much anyone. My supervisors, like I mentioned before, PCS Sarah Chadwick is another one. I can't say. I would, if I had to guess, over 20.
Okay.
Maybe more.
What was Director Susan DeHaan's response as after you were walked out and you were in the administration building when you can you describe what you stated and what your emotional state was like?
Yes. When we got into the conference room, I was already crying, and she was matter of fact with the process that she was explaining to me. She explained everything regarding the administrative leave with pay, and in between that, I remember just crying, and almost to the point of not being able to talk again now. And I just remember saying that I'm a good employee and I'm having difficulty, and I've been trying to work on it, and with my doctor and with meds, and I'm supposed to be on medications that stop it, and they don't prevent it, I should say, and they haven't. And it's just been a long, difficult process. And I explained that to her, and I outright asked her, so am I going to get fired, I think I used the word, and she said, well, I mean, you've had, I forget exactly, she didn't say this specifically, but well, you've had all these chances and it pretty much looks like that. And she asked me if I had anyone to talk to about my options and she asked me when I'm able to retire and that I need to reach out to someone about my options.
Are you aware of any other WRC staff who took their own lives while on FMLA?
I'm going to object to this. This is a question about Saj Baldwin, which we've already gone over.
Chairman Davis, there's more than just Saj Baldwin.
So I just don't think it's relevant. So I'm going to sustain the objection.
We want to emphasize that the relevance is how this mistreatment of staff with serious medical conditions affects those staff. And the appellant knows of a person she was close to at WRC who took her own life. So
to the extent there's any possible relevance, it's going to be to the witness testifying about how she was mistreated and what that meant for her. I doubt that that's really relevant here, but as to other people unrelated to her, not relevant, I'm not going to have it become part of the record.
how did it make you feel to know that Shannon had taken her life at WRC?
So I think we're
I'm
back
going to object.
right? I've already ruled on this, Ms. Irwin. We're not getting into that.
Is it reasonable for someone with a chronic migraine diagnosis to report their migraine in advance?
I'm going to object to that question as it asks for expertise.
There's no one that knows her condition better than she does, Chairman Davis.
So
ask her if she feels that she can call it in advance. She can't, I mean, my objection is that she can't speak to what migraine sufferers in general can or can't do. She's not a doctor.
Okay, thank you. How is coworkers tracking call-ins and FMLA usage? How is that relevant to your case?
It played the number one reason why it took me so long to say to myself that I am physically not able to improve my situation and reach out to my physician. And mind you, I thought that my FMLA in October was still covering me. And that is evidenced by me calling in for full days in 2026 under FMLA. And it took about, I want to say, around 2 times of doing that before I was talked to by Jacob Relian, the FMLA coordinator in HR.
And what did he tell you? Did he inform you that you could get FMLA for the tardies?
No, he just informed me that I was not covered under FMLA in 2026 and explained that it's not based on a 12-month period, it's based on calendar year, which I just did not realize that. And that is on me because I had paperwork showing that, but I just didn't. I personally did not think it was that. I thought it was 12 months. And I had been on FMLA previously. And the whole time, each time for medical and mental, that I thought it was a 12-month period, not a calendar year. And I could have sworn that's how it was when I first went on FMLA, back when I was working in Madison.
So the FMLA coordinator at WRC, he informed you that even though you got your FMLA certification in October of 25, it expired the end of December 25.
Correct.
So January, February, you believed that your FMLA covered those tardies.
Not at that point. I believed my FMLA covered my full days that I had called in. I made it known to my supervisors, my struggles with my chronic condition, and I was never told about that with tardies. It could be covered under FMLA, and in discussing it with my neurologist after the fact, he said, absolutely, I can do that because it's related to migraine flare-ups.
So it wasn't until March when you were talking to your neurologist that you learned that the tardies could be covered by FMLA.
Correct.
And that
Because at that point, I thought it was a new year and that I had been feeling good. I could control it. And in hindsight, obviously I was wrong.
is it reasonable for someone with a chronic migraine, is it reasonable for your case, to be able to report your migraine in advance within 90 minutes of your shift?
Sure, there were instances 100% that I was able to before the 90 minutes, but not all.
And how many of those tardies did you call in for?
In 2026, I called for 3 out of the 4.
And within what time frame did you call in to report that you were going to be late?
Probably between 5 and before 6.
So would you say that was 60 minutes, about 60 minutes prior to shift, you called in on 3 of your 4 tardies?
I would say within, but not.
Okay. Within.
That would be within.
Can you describe how those 4 tardies, how that occurred with, what caused you to not call in that 90-minute time frame?
So my symptoms for the 3 where I did call before 6 a.m. were on that edge of where is it going to start to get better, because I take medication at the onset. And obviously when I'm sleeping, if I know I would, if I get woken up from it, I would try to take my medication right away, and in hopes that I could make it to work. And so in those instances of the 3, I was struggling as to whether I should just call in for my, what I thought was approved FMLA full shift. But I don't like doing that because I know it causes staffing issues, and I don't want to put a coworker in the situation of being jammed because of me. And so on those instances when I am tardy, it's because I'm trying to figure out if at some of those instances, if I can even make it into work for the full day. And I want to, and so I see, you have to see how the medication is, and if it's not relieving any of my symptoms, I can't come in, but it's well past the 90-minute call. So 90 minutes before my shift is before 4:30 a.m. and my alarm was set for 4 a.m. every day I had to work. And so there were occasions, if I may speak for last year and this year, 2025 and 26, where I didn't even comprehend that my alarm had gone off. Like I was in that much pain.
How many, for each of the tardies, how many minutes late were you?
For 3 out of the 4, it was 14 minutes or less. And then for the one that I didn't call in before 6 a.m., I would receive the phone call from Ops PCS asking if I was coming in, and no, I forgot the question.
How late were you for each one?
Okay, so then on that day, I took, and I told them that, him or her, I don't remember which PCS it was, that I would be in by 8 a.m. because, as I said, I strived to come in because I didn't want to put people in a jam.
Can you describe how you felt about your job as a 28-year employee of the respondent?
In every position that I've had, I took pride in my work. And coming to WRC was a complete 360 of what I had been doing for the state, which was in the forms and records and transcription department. And I took pride in my work. My supervisors recognized that in my PEPs, and told me to my face multiple times, hundreds of times. And question.
Can you describe what PEPS is?
It's your employee performance for the year. And it's based on a 12-month period.
Can you describe any of those performance evaluations that stand out in your memory?
Many, but particularly with my current supervisor at US WIT, which he became my supervisor in the fall of, let's see. He had been my supervisor for several years. Like, I can't say for specifically. And in our performance evaluation, I did many things because I was in the office for our unit on the computer, and he recognized that. And he recognized my rapport with everybody, inmates and staff, and said that he tried to help me as well in this process. And I discussed with him my deep angst about causing people overtime and that the whole situation. And he reached out to me when I was on administrative leave, which meant the world to me. And he said that he just is holding out that termination wasn't the end result because he didn't want to lose me.
How long were you on administrative leave for being tardy?
I was on from, I believe the date was February 20th on my 4th tardy, and was terminated April 2nd.
So that is like over 2 months of not knowing if you were going to be terminated.
Correct.
And that was after the warden or the deputy director DeHaan informed you already that you were probably going to get terminated.
Correct, but not deputy. She was the
Or director,
Yes,
the director, Susan DeHaan. So how exactly did she state it when you were walked out? Regarding what she believed the outcome of your discipline was going to be?
I believe I had addressed this earlier, but I can see her, how she did this with her head, as she said, well, it pretty much looks like that. And that's when she said, I need to have somebody to talk to about my options.
So it felt to you that the decision was already made.
100% it felt like that day.
Are you aware, after you got terminated, were there any employees that remained employed at WRC after serious misconduct that were not terminated?
I'm going to object. I've objected to this question previously, and unless it's talking about other employees with tardiness issues, my position is that it's not relevant to this case.
So we have discussed this previously. We're not going to get into anything other than tardiness or failure to call in scenarios.
Okay, thank you. Are there any other staff at WRC who you are aware of who had tardies, multiple tardies, and did not get terminated?
Yes.
Can you describe what you are aware of as to the number of tardies certain employees, whether they were male or female, and how many tardies you were aware of that they were not terminated for?
I can't speak to the specific amount. But I was aware of whenever a coworker came in late. I had during our 9-week training when I first started, one of my coworkers in the training, brand new, not brand new, but I was aware of her call-ins and of when she was tardy and other things not related to that, but having almost 28 years of state service, it actually shocked me that it took so long for that particular individual to be terminated on probation.
So
For that,
how
'cause
many
we
would you
were
say?
told when I first started in 1998, you have to attend work regardless, and people got fired if they were on probation and called in even one day.
So,
That's what I was told by coworkers.
so how many tardies were you aware of with that employee on probation? Estimating how many tardies there were that she did not get terminated for?
Eventually, I don't know what her termination was, but she was terminated, but I would say I can think of a handful for sure, which means at least 5.
And are there any other staff that you're aware of arrived late consistently and were not terminated?
Yes, but again, I don't know their situation and I don't know how many times, but yes. And in this particular instance, on first shift, his direct coworker had commented to me when I was going through this that he's got issues all the time, and I was told he was on FMLA. I don't know that 100% because this was his coworker. So all I know is that information was given to me and said, you know, it's happening with him. And he was on administrative leave at the same time I was. No idea why, but he got his job back. I
And
didn't.
is there anyone else besides those two that you are aware of?
Yes. I'm aware of someone that they worked with who had a diagnosis of alcoholism, and they worked with him on that, coming to work with alcohol in his system. And it took him a long time before they terminated him.
So you observed accommodations being made for someone coming to work intoxicated, others tardy more than 4 times, and were not terminated.
Yes. We're not terminated for that specific purpose, correct?
Why do you believe you were terminated when you were?
Objections calls for speculation.
I'll overrule it. You can answer the question.
To be honest, I just didn't feel that director and deputy director, that it mattered, and that it just didn't feel like they cared about me, and that all of my efforts at doing a good job in every position just didn't matter.
Can we please bring up exhibit 37, please.
A37.
Yes. Thank you. So do you see here that, we'll get this. This is, the Wisconsin Resource Center, posting, and they're saying, WRC offers rewarding work with rewarding benefits.
Yes.
Do you feel that, that is a true statement with the situation that you're in?
No.
And do you see here that WRC is a leader in the development of treatment methods for state prison residents in need of specialized mental health services?
Yes, I see that.
And how does that make you feel when you read that your employer emphasizes how well they care for inmates in need of specialized mental health services?
To be honest, I think that's part of what drew me to change my career was the treatment that inmates received at WRC. Mental health treatment, I should say, qualify that. I remember being told that we were the only, WRC was the only one, either, I feel like it was the only one in the United States that has something like this.
So
This was back when I first started at WRC.
So when you first started at WRC, did you believe that the employees were going to be supportive and maybe more welcoming? Can you describe that? What you expected going into employment with this employer, knowing the treatment that they offered to the inmates?
Well, I knew people at that time that had worked there, close friends and relatives, and I knew or assumed I would be welcomed, and I was. In training, actually, at PCS Chadwick, when she was training officer or whatever her technical title is, reached out to me during the PEP that I had that she performed in and said, have you thought about being a PCS?
So you were,
And so I felt valued by immediate supervisors, and
so it was,
welcomed.
yeah, so it was even discussed from what your supervisor saw in you that you would make a good supervisor.
Yes, because I had a history of supervising staff previously, and she commented on how my communication skills and other things in that regard. She could definitely see me being a PCS. And I had told her that my experience as supervisor, it's just too stressful.
Can we then move down to exhibit A38, please? Do you recognize this as the, if you can scroll down just a touch? Or up, sorry. There we go. So do you see this is the Wisconsin Department of Health Services vision, mission, and values, our vision statement?
Yes.
Do you see here that it states everyone living their best life?
Yes.
Their mission is to protect and promote the health and safety of the people of Wisconsin.
Yes.
Do you feel that the respondent protected and promoted your health and safety?
Not overall, no.
Can you describe why that is?
Because other than my immediate supervisors, I was contacted once by Gina last year about whether or not I needed FMLA. I just felt like I didn't matter to the high up supervisors, I guess, the administration, and I felt like my medical condition, although chronic, just wasn't like somebody who had alcoholism and other things. And I just did not feel valued. And I certainly didn't feel like they were promoting my health and safety.
And do you see in their values, under their our values statements, how the Department of Health Services, the administrator was Ginger Steele, who testified. Their values statement mentions collaboration, honoring the expertise and perspectives of colleagues and partners, that they show and earn respect through their words, choices, and actions. They uphold by being honest, transparent, and accountable. And excellence, they're compassionate public servants and good stewards of taxpayer resources. Talking about excellence in all of their actions and interactions. Do you, with your experiences, is this a true statement from the Department of Health Services of Wisconsin?
If I can answer partly, because I do feel like part of that is true, depending on who I think about. Overall, as the DHS, we always talk about Madison, and that refers to the administrative that's located in Madison, and I just didn't feel that there was collaboration. I think excellence is a strong word. In my opinion.
How about
Situation.
when we go down to justice, where the DHS claims that they commit to cultivating fairness, equity, and belonging within their organization and through their work? Do you think your termination, do you believe your termination was fair? What was not fair? What do you feel was not fair about your termination?
If you look at this, I would have expected to have collaboration with HR. And I didn't have that. As I stated, Gina reached out to me last year and asked if I thought FMLA would be appropriate and help. And I don't know if it was email or phone, but I told her how I am trying to do it myself. And because of, I didn't want to be one of those, oh, on FMLA. And they're calling all the time. Because I heard that from coworkers, especially a couple on third shift that kept track of it all.
So you, again, just to reiterate, it wasn't until your neurologist informed you that you could get this reasonable accommodation of arriving late or calling late on 1 to 2 times per week. It wasn't, would you say that that was not even excessive of an accommodation?
To be honest, I was surprised the very first time I got intermittent FMLA that it was so frequent. 1 to 2 times a week. And if you look at my history with that, I was never close to that with calling for full days.
Yeah, so you had, even though you had the FMLA for it, your flare-ups did not come with that amount of frequency.
No, not even close to that. Earlier it was mentioned that I had, I forget what, 8 tardies. I remember getting 8 tardies in 2025, and my FMLA was written in 2026 for 3 to 4 times a month. And I had 2 in January, 2 in February.
So you had 2 in January and 2 in February. So that's 2 per month of the flare-ups that you had.
Yes.
Would you say that that clearly shows that you were not abusing the FMLA process, because you believed your FMLA was covering those?
So I believed that in past practice, I'm talking about myself only. When I first needed FMLA, it's never before things happen, and it's always been backdated. So
yeah,
this is what occurred this year, and I didn't know until talking to my provider, my neurologist, about the tardiness. And I know it's a 24/7 facility, and
so I think that's a key point.
and I think I just want to say, I know it's a 24/7 facility, and that is why I tried not to, you're given 2 whole hours for being tardy, and I strived to get in as soon as I could. And if you
So I'm going to jump in, just say a couple things, just because I think it's fair. You know, Attorney Makovic has been gracious appropriately in letting much of this testimony come in. I'm not sure much of it is relevant, but I'll say a couple things. WRC is not going to decide. You were not terminated for violating FMLA. Point number one. You were
Right.
terminated for being tardy.
Mhm.
Point number 2 or 3, all of those prior instances, whatever the merits were or weren't, when you were disciplined and you did not appeal, that's the end of it. We can't go back. We're not going to go back and relitigate whether you should or you shouldn't. You had an opportunity to appeal. You didn't. So you were on the double 5-day when the termination occurred. So that's just the reality from the WRC's perspective. Bottom line, as to the tardiness and as to the flare-ups that can't be anticipated, what is your answer as to what would happen if you got your job back? Why would the employer not believe she's going to continue to be tardy because through no fault of her own, she has a condition that she can't control? What's the employer supposed to think about that?
That it's a right of my FMLA. And
So let me stop you there. I'll just say that's the legal issue here, which I don't know the answer, is whether FMLA excludes call-in obligations, right? If it turns you're right that FMLA protects you, I would think you're going to win this case. Flipping it around, though, if it turns out FMLA does not protect you against the call-in obligation, then you did not meet the obligation that you knew existed. And my question for you is, if the WRC were to reinstate you or the employer were to take you back, what's going to change? What is it that makes you think you're going to be able to become more able to honor the tardiness requirement on a regular basis? From what you've said, I don't see any reason to think it's going to change.
am I allowed to answer?
Of course you are.
Okay. It was discussed with my immediate supervisor and PCS, Witt and Bonsa, that if it came down to it, they asked me, would you consider switching shifts? Do you think that would help? And I said, absolutely. If it meant that I would keep my job, I would go on third shift, which I would have, if I can explain, my husband is also a PCT and works third shift. He would be able to be there to help me and meet the requirement of the 90 minutes because he's there with me. And no, he can see if I'm just unable. And I know there's history of others, couples, spouses that have had to call in for their spouse because they weren't able to. And as much as I hated third shift for my physical and mental health, I was absolutely willing to do that, and I wasn't given a chance.
So, in response to that, you indicated you discussed that apparently with your immediate supervisors. Did you ever talk to the bosses about that as an option? Did you ever raise that in your mitigating statement? Hey, shift me to third shift?
With like the director or anybody?
Yep. Or on your pre-dis?
Did you?
I am 100% sure I talked to it with Brittany Keynes and PCS. Mike. Is it Mike? PCS Zivazek.
So the problem
during the actual investigation, I can't 100% tell you yes or no. But I spoke to those two people because they did a lot of my investigations about that and that. I was told,
Reasonable accommodation.
I was told that, basically, I was led to believe that I was going to be given a chance at the end of my investigation to bring that forward in that,
So why did you think that?
because that's what I was led to believe by my immediate supervisor. In past practice, recently, in 2025, we had several investigations going on for not attendance, and it was led to believe that they were given a chance to resign, or they were given other I don't know if accommodation is the word, but, and I wasn't. So I was expecting that I was going to be given the chance to resign or be terminated. And I was just told I was being terminated, and it was on the phone. And that was it.
So I suspect we're way too far down the road for that to occur now, but I will tell you that historically, even at this date, employees who say to the employer, I'll drop my appeal if you'll let me resign, typically the employer says, yep, we'll let you resign. So I'm just throwing that out there. If you decide that's an option you want to pursue, you could make that proposal to Attorney Makovic. He'd take it to his employer, the bosses, and they might or might not approve it. I'm guessing there's a fair chance that they would approve it if that turned out to be a meaningful end of this process for you.
That's not what you're.
Thank you, though.
Can you
You're welcome.
you mentioned the accommodation 312?
So there
So
is.
again, we're back to maybe the legal issue. Okay, the employer's position is they have no obligation to accommodate as to tardiness. Ms. Irwin, it's going to be your problem to tell me in the law why that's not so. And
Yep.
Attorney Makovic will be telling me why it is, why they have no obligation. And I don't know the answer to that, but talking more about accommodation here, we know that's your position. They had to accommodate, they didn't accommodate. Maybe you're right, maybe you're wrong, but I think we've beaten that horse to death.
Okay. Can we just add one point and then we will rest?
Yeah, you can, depends on what the point is, but go
Yeah.
ahead.
Thank you. So, did you ever request reasonable accommodation from the HR director?
Yes, I emailed.
Reasonable accommodation for what?
So I had no idea that was available to me. All that's ever been talked about is FMLA. And had I been involved in a collaborative process with HR, it would have came up where I said a reasonable accommodation would be switching to third shift. And I didn't even know that until after I was on administrative leave for a couple weeks, because I emailed Gina Leipold Ruby on March 12th that could I get information? How do I do that? And her response was a link to do it. I didn't get any discussion about it. I had to look up all on my own how to even apply for it. So that's never discussed about accommodations. Only in the training will they tell you a little blurb about has to be a reasonable accommodation, and
your employer has to agree with it. I was told that in my training when I first started at WRC. I remember that, and that's it. No further discussion. And if I'm having all these tardy issues, why wasn't I offered to be that discussion, even have a discussion with upper management, with HR director?
So I'll add one more piece of the puzzle. I think like body language from your representative indicated that you're not interested in the resigning option. I'll just say, yeah, that is an option for you. And as I indicated at the start, if this goes up on the WRC website, it's up there for the world to see, for better or worse, right? I mean, I'll going to protect your medical information, so that's not going to be out there. You can be assured of that. But you could also propose to the employer, if you wanted to, hey, I'll come back to work, no back pay, and work third shift. That's my settlement offer. And if you were to agree to that, I'd drop my appeal. Right. Now, I have no idea whether the employer would have any interest in that. But to the extent, from what you've said, you are a valued employee. To the extent there's no financial liability to the employer doing that, to the extent that seems like a plausible way forward that would potentially deal with the problem of calling in within the 90 minutes, that's at least something I would say to you, you could think about. You could propose to Attorney Makovic. He'd run it up the flagpole, see if there's any interest or not, and he'd let you know whether that works or whether it doesn't.
I would absolutely consider that.
All right. Well, again, you would need to, through yourself or Ms. Irwin, formally make that no back
Okay.
pay, go back to work, third shift, and we're done. And then, we see whether that works or whether it doesn't.
Thank you for that.
Yes, thank you so much for that.
No, you're welcome.
And we're ready to rest.
All right. Attorney Makovic, any questions?
Yes. Ms. Schultz, you had FMLA in place in 2025, right?
If my memory serves me correct, for the last couple months.
Sure. But you didn't have it in place unless it was retroactive for the earlier part of the year, right?
Correct.
Okay. And
Well, actually, can I restate that?
Sure.
I don't remember what my 2025 FMLA stated, so I can't 100% say that is correct because I don't
okay.
have it.
But is it fair to say that you do remember it being in place in the later part of the year?
Correct.
Okay. And do you recall sorry, let me back up here a little bit. Is it your position today that all of the tardies in this situation and the one leading up to it are due to your medical condition?
When you say this situation, do you mean of 2026 only?
Well, let's start with 2026. Are all 4 of these tardies in 2026 due to your medical condition?
All 4 were definitely due to my medical condition.
Okay. Then let's talk about 2025. Ms. Irwin, please don't provide her notes. Examiner Davis, can we get an instruction not to be instructing the witness I see when I
we
see you
have-
passing a note, that's really improper, I think.
It's flipped. I flipped my phone. It's for when I do my cross of her. I apologize.
All right. So clearly, Ms. Schultz, you're just supposed to answer the question as you would without any coaching or head nodding or otherwise from Ms. Irwin.
Yes,
So thank you for that.
yes.
Go ahead, Attorney Makovic.
All right, thank you. Now, going back. Going back, Ms. Schultz, let's back up here a little bit. The repeat 5-day discipline was the tardy in that instance a medical issue?
I cannot say for sure which tardy was the cause of that.
Okay, so were all of your 2025 tardies medically
I would
related?
like to object that we were not going to be discussing the 2025.
Excuse me. Attorney Makovic, what do you have to say about that?
I am going somewhere with credibility, depending on how she answers these questions. Because I have, depending, I believe that there may be credibility issues regarding this.
All right. On that basis, I'm going to overrule the objection. You can proceed.
Sure. I 100% did not have a medical issue for each and every one in 2025. And it is stated in my investigation, I was in a car accident. I was having an issue, car accident, and I had the train issue and was not covered for the train issue for one of those. Because at that point, I believe it was that email that we talked about going out saying that it was no longer going to be just a blanket okay that you were late because of the train. So yes, I absolutely 100% did not have every single tardy, but were there? Yes. Related to my medical condition.
All right, thank you. And you were seeing your doctor on a regular basis in 2025, correct?
Yes, I was seeing my doctor regularly.
And it was I'm not going to pull it up, but it was roughly it was every month to couple of months, right? Something like that.
I can say for sure I saw him every 10 weeks.
Okay, yeah, it's in the document there. When you were seeing him in 2025 and you were having these disciplinary issues, you didn't think to ask, Doctor, what can I do to what can I do to address the issues leading to my tardiness?
I assumed, and in retrospect, obviously, I assumed wrong that I work at a 24/7 facility, and I just assumed that it wasn't even a possibility, especially after I was told that my current FMLA in 2025 was for full shifts, full days.
All right. And earlier you stated that either the culture or some of the statements that you'd heard, about WRC made you unwilling to reach out to your physician. Am I stating that right?
Unwilling? That would not be correct.
Okay. I must have noted that down. Were you reluctant to talk to to meet with your physician?
I was not reluctant to meet with my physician. I was reluctant to, in 2025, go on FMLA and prior years because of the stigma.
So which is it? Were you unwilling to go on FMLA, or did you not think that FMLA was going to cover you?
It is not unwilling. So I do not like that word. And I was covered under FMLA for full days. I was told it's only for full days. So my assumption was if I was going to be late, that's not covered under FMLA. That was my assumption. So why would I try to talk to my provider about it? Because the assumption I got from HR was that it's not covered and it would not be covered. So I was struggling on my own to try to fix the problem, and I obviously could not.
And that was based on your assumption.
And it was 100% based on being told that when I tried to come in for part of my shift, that I was not allowed to do that. So
sorry, you just stated that it was your assumption that this wouldn't cover tardies based on
that,
so it was your assumption then.
I'm confused.
So I'll move on. Now, you stated that you called in on 3 of the 4 tardies here in 2026, right?
Correct. After
Okay.
between the 90 minutes and my start shift, yes.
Right, but and it was you acknowledged that it was less than 90 minutes before the shift.
Yes.
Okay. And when you have a tardy slip with a notification of attendance work rule violations, you sign that slip to acknowledge it, don't you?
Yes.
And you have the opportunity to look at it, right, when you sign it?
Yes.
And you can say, hey, this is not right. Can't you?
What's not right?
If you catch an error, you can say that's not correct, right?
Sure.
Okay. I'm going to share my screen right here. This is part of Exhibit R4 here. Now, do you recognize this? I'm sharing the right screen, right? Am I sharing notice of attendance work rule violations?
Yes, you are.
Okay. Okay, good. Thank you. Now, Ms. Schultz, do you recognize this?
Yes.
And is that your signature down at the bottom under employee acknowledgement?
Yes.
Okay. And that lists the time arrival at 8 a.m., right?
Yes.
Okay. And there's nothing in the time call space, right?
Yes. Correct.
Okay. All right. Then I would like to look at this next one here. This is the second one from January 16th, right?
Yes.
Okay. And this is the one that was 3 minutes late.
Yep.
Okay. And time arrival is listed as 0603.
Yes.
And time call has a dash on it, right?
I see that. Yes.
Okay. And then you signed this acknowledging acknowledging the notification, right?
I signed it acknowledging that I was tardy.
Okay. Then this one here, it's a little tough to, this one again, this is the one that's really tough to read. I apologize, but when I say that it looks like there is a time here entered, listed as time call, and your signature on the bottom, does that sound right?
Yes.
Yeah, this one has a time, right?
Yes, very faintly.
Very, very faintly. I don't know why that one's pink.
And I have bad eyesight, reading eyesight, so yeah.
Yeah. All right.
My
And then we've got the last one, number 4 here. February 20, again, right? Now, this one, you signed that one at the bottom under the employee acknowledgement, right? Okay. And it has a time arrival listed as 0614.
Yes,
And then there's no time call listed, right?
right.
Okay. So with these, you only one of them lists a time having called in, right?
Yes,
And so you acknowledged all 4 of them, acknowledging that that these slips had information written on them and they were shown to you, right? Okay. But none of them you corrected about the time call.
no. I don't believe it's written on a lot of my, so I guess I didn't even catch it. And that is truthful. I did not catch it. That's on me.
Okay. And you you do you recall being interviewed by Brittany Keynes, right?
Yes,
Okay. Is it fair to say that you may not remember all the exact details there,
fair.
considering that it was 4 months ago? Sorry, I'm asking myself to do math. 4 months ago. Okay. And when it comes to the situation of having called in, do you think that that would have been relevant information for the investigator?
I believe I said it. I can't tell you 100%, but I believe I said it in discussion. Whether it got recorded or not, I don't know. I didn't believe I saw the exact document that she typed in every meeting what I was saying. Did I see any of those? No.
And when she said, "Is there anything else you would like to add?" That would be a time to mention that, right?
Yep. And I did.
You think that you did?
My mitigating circumstance, I mentioned.
Your mitigating circumstance you mentioned. Okay. But not in your investigatory interview?
I don't know. I can't honestly remember each specific interview.
That's fair. That's fair. All right. So then in your so you think that it was either in the interview, or do you think that it was either in the interview or the pre-disciplinary meeting, or are you confident it was in one particular one? Talking about
that we discussed it in both meetings.
You're confident that you discussed it in both
I'm
meetings?
confident.
Okay.
I
Okay.
didn't say 100%, but I'm confident.
So let me jump in just so I'm clear on what it is. I may have lost the thread on what the back and forth, what it is from your perspective, Attorney Makovic, for the purpose of your question.
For the purpose of my question, what it is the fact that Ms. Schultz believes that she called in
very good.
on 3 of those dates that she was tardy prior to arriving.
Very good. Thank you.
Okay.
I am confident that was discussed in for sure one meeting.
Okay.
If I had to guess, I would say the pre-dis. But it could have been both.
Okay. All right, thank you. I have no further questions.
Any follow-up, Ms. Irwin?
Is there anything else that you would want to elaborate on?
Just because this was the last thing we talked about, in watching crime, TV shows, whatever, I know that you can subpoena phone records, and I am 100% confident that my phone records would show what time I called.
Is it your job to correct supervisors?
I mean, what do you mean by that?
Is it your responsibility to look at a document that your supervisor creates? Is it your responsibility to correct that supervisor when an error is made?
Responsibility? No.
Do you trust, when you were working, did you trust that when the supervisor provided you with the documentation of your tardy, did you trust that that was correct?
Yes, 100%. I assume they know how to do their job, and it was correct. Yep.
I would say we rest.
Anything else, Attorney Makovic?
No, thank you.
All right. Any other witnesses, Ms. Irwin?
I put myself down as a witness. Can I just inform you of what the FMLA statute is
No.
that covers tardies?
No, you can just put it in your written argument.
Sounds good. Then we will rest.
Very good. So let's talk about exhibits. Excuse me. I should ask Attorney Makovic, do you have any rebuttal witnesses you wish to offer?
No.
All right. Let's talk about exhibits. First, Attorney Makovic's exhibits. Ms. Irwin, do you have an objection to the commission considering those exhibits?
No.
All right, they're received. So, Ms. Irwin, you have a ton of exhibits. I'm believing that Attorney Makovic's going to object to some. I believe, in effect, I've already sustained the objection to some. So we can go about it two different ways. One would be for you, Ms. Irwin, to take a look at what you've submitted, proposed, strike those that in effect I've already said I'm not going to take, and then offer the numbers and Attorney Makovic can react, or we can go one by one through all 30, whatever they are. Either way works.
Well,
Go ahead.
I'm excited to tell you that I am ready with the exhibits that were not objected to.
All right, well, let's tick them off and go one by one, and Attorney Makovic can indicate whether he objects or not.
Okay.
I know there's some duplication.
A24.
All right, wait for him to check it.
Sorry, are these exhibits you're moving into the record, or are these exhibits you're withdrawing?
Exhibits we want to move into the record.
Okay. I'm actually going to object to A24 because our position is that even if our position is that FMLA was not in place at the time it was retroactive, and even if it were, it does not obviate Ms. Schultz's requirement to call in prior to her shifts when she is tardy.
And what is A24?
That is DHS HR policy 409, Temporary Family and Medical Leave Act policy.
So you don't need to put that in as exhibit. You can argue off that in your written argument.
Okay. The next one is A7.
I just want to look at that. I think that's in my exhibits. I have no objection.
Received.
A4.
That's in my exhibits. I have no objection.
Received.
A18 is also in his exhibits, I believe.
I don't have a note of an issue, so yeah, no objection.
Received.
A1.
No objection.
Received.
A17.
No objection.
Received.
A5.
Just a moment. Oh yeah, no objection.
Received.
A19.
Yeah, I'm going to object to that one. And I'll give you a brief statement why. That is DHS or Travis M. That is based on the WERC case Travis M versus DHS. And the issue there, I remember because it was my case, was that Travis M was terminated for using leave without pay. And he called in sick the day of. The question at issue ultimately ended up being, did he have, was it excused that he did not ask for FMLA that he knew he had in place and that his employer knew he had in place, and the fact that he was suffering under a mental health crisis was considered to be a mitigating factor? The reason why I am objecting is because I believe that this is being presented as as a comparative case, and I don't believe that it applies because they are different, because this is a situation where that appellant had FMLA in place. He knew it. His employer knew it. He didn't quote unquote use the magic word of saying I'm taking my FMLA, but I'm sick. And he said, I didn't think to take my FMLA because I was suffering this mental health crisis. And the further issue is that he ended up, originally he was issued progressive discipline for using leave without pay. FMLA applies directly to that case because that is exactly what FMLA is for, protecting leave. And the reason that is different and why I'm objecting for Ms. Schultz's case is that Ms. Schultz was not disciplined for improperly using leave. She was disciplined for not properly notifying, for not properly alerting her work unit according to the policy that's required for advance notice of tardiness.
So, as with the policy that you proposed, you're free, Ms. Irwin, to argue why that is relevant to the case, but we don't need it as an exhibit. It is what it is. You can argue about it. Attorney Makovic has sort of presented his argument. You probably have a response and you can save it for the written argument, but I won't receive it as an exhibit.
That sounds good. And then A20.
I object to that. That was objected. The testimony governing that was objected to and sustained.
I'm fine with that.
All right.
And then that's all for, that we have.
Very good. Then we've covered the exhibits. It seems clear, I think, that everybody wants to, or at least Ms. Irwin wants to, and I expect Attorney Makovic will as well, send me something in writing. Is that correct? If it's not, we can do it today.
No,
Yeah, could we do it today?
We can. Absolutely. I don't know if Attorney Makovic is ready today or not.
Yeah, I can do it. I'm ready.
Very good. All right. We can do it today. Absolutely. And, to the extent you do it today, I was hoping you can point me to whatever I ought to learn about why FMLA does or doesn't cover tardy calls, that being kind of a key threshold issue here. So,
Yes.
anybody need any little time to collect themselves, or are we ready to go with the oral argument?
We're ready.
Yeah, I can go now.
All right. Attorney Makovic, you go first. Feel free to proceed when you're ready.
Thank you. Today, the department has proven by a preponderance of the evidence that that Lori Schultz was terminated from was discharged from employment by DHS, and DHS had just cause to do so. That just cause rested on really the three factors of our just cause analysis: whether she violated work rules, whether that violation of work rules warranted discipline, and whether that discipline was excessive. Talking about, did she violate work rules? Here it is. Factually, I believe that the facts are not in dispute. There were 4 instances in 2026 where Ms. Schultz was tardy. She was tardy. She arrived late to work and did not provide the proper notification under the policy. The policy, WRC Employing Unit Memo, that attendance policy, states that staff using unanticipated leave have to alert their employing unit no later than 90 minutes prior to their scheduled shift. Ms. Schultz acknowledged in her testimony that for none of these absences did she call in more than 90 minutes prior to her scheduled shift. So there's our work rule number 2, our failure to comply with written agency policies or procedures. And that also includes work rule number 5, a failure to report promptly at the starting time. Also failure to promptly notify the proper authority of impending absences or tardiness. It is acknowledged, it is part of the record, it's not disputed, that on the 4 dates in question, Ms. Schultz did not arrive to work starting at 6 a.m. on those dates. That's failure to report promptly. And according to the policy, the policy tells us what promptly notifying the proper authority of impending absences or tardiness is. We're talking about 90 minutes. And she failed to do so. So on both prongs of work rule number 5, the facts support that conclusion, the facts support just cause there. And work rule number 6, unexcused or excessive absenteeism or tardiness. That one does not have a specific, that one does not, in the work rule at least, have a specific number. However, when we're looking at, we can look at policy to inform us here that really that 4 times, the four times in a calendar year triggers discipline. So she violated that, violated that work rule. So we have 3 work rule violations of 3 work rules. There's our first step, straight up. Then does it warrant discipline? Ginger Steele testified about this, and she testified about how important it is to have people who show up for work. The fact that they take it seriously. Part of the job for PCT is includes showing up for a work schedule and showing up for what may seem to an outside observer to be a strict work schedule. However, it is DHS's prerogative to state that people in a position such as a PCT, I think I said PCS earlier, but that people in a position such as a PCT have to appear at their start time or by their start time. And if they're not, they can trigger disciplinary matter. They can trigger disciplinary investigations. So that warrants looking at the disciplinary track. Then we're talking about, does it warrant the level of discipline that is imposed? And Examiner Davis, I don't think I need to tell you, but I'm going to state it anyway. That third step in the test of whether this discipline, was whether it was the proper level of discipline imposed was this discipline excessive? That's a much harder question when there's a skip in discipline, or when there's a skip in progression of discipline. Here, Ms. Schultz was terminated on progression. That's not in dispute either. She was terminated on progression. And if we look back over from 2025, starting in May of 2025, this is Ms. Schultz's 5th discipline for tardiness. Normally, your 4th discipline is termination. You get your 1-day discipline, your 1-day suspension, your 3-day suspension, your 5-day suspension, and then the 4th one is termination. However, DHS has a policy. DHS gives its employees some grace in that if they have another attendance violation, they can get issued a repeat 5-day suspension. That's what happened with discipline number 4. So, and technically, just to be make sure I'm completely accurate, technically the first 2 levels of discipline, the 1-day and the 3-day, those were letters in lieu of suspension. So those were, written reprimands in lieu of suspension. However, for the purpose of progressive discipline, those have the force and authority of a 1-day suspension and a 3-day suspension for the purposes of progression. So following progression, that's in the statute, that's in the work rules, that's in DHS's policies. Following progression is really by default not an excessive discipline. The only issue is if there is some sort of mitigating factor that warrants reducing this level of discipline. One that comes up a fair bit is under the Morris standard, a disparate treatment. We're talking about similarly situated employees. As Ms. Schultz's representative stated when she was asking Sue DeHaan questions about comparators, acknowledged this is a unique situation. I shouldn't have to go further into the discussion of disparate treatment and similarly situated employees, but I will anyway. There were a few people who were raised, a Daniel Krause, a Dylan Coons, that they were acknowledged. These are people who were acknowledged to have had attendance issues. However, Sue DeHaan and Sharon Harder both stated that Dylan Coons had he was involved in different issues, and we did not have any evidence on the record that Mr. Coons was faced with a similar situation, that being having had a repeat 5-day for attendance already, then receiving another discipline or another tardy and not facing the that same level of punishment. So there's no evidence in the record to support that. Then further, Ms. Irwin has presented information, including testimony from Ms. Schultz, about various other factors that they believe should be considered as mitigating factors, such as good work performance, long work history, and as Ginger Steele stated in testimony, there is an extent to which and a point at which that stops mattering. In short, it is DHS's position that having good work performance in the past, having a long tenure, that only gets you so much. That only earns you so much grace. If you're a 30-year employee, it's not a get out of jail free card. If the discipline continues, if the discipline stacks up, it's not this case, but it is something that does apply. If something is particularly egregious, it doesn't matter how long you were working and how good an employee you were otherwise. And in this instance, really, we're talking about 5 disciplines for tardiness inside of a year. You could have been working since the founding of the state of Wisconsin. That wouldn't be enough mitigating factor if you can't show up for work. Then Ms. Schultz and her representative, Ms. Irwin, have raised a lot of questions about FMLA, Family and Medical Leave Act. Their position, they haven't made their argument yet, but I'm pretty confident that their position is going to be that FMLA forgives this, that FMLA warrants reducing or even overturning entirely this discipline. Here's why that is incorrect. First, Ms. Schultz did not have FMLA in place at the time of these disciplines. She did not have FMLA in place at the time of all 4 of her tardies in 2026. Additionally, this is not a situation. This is not a situation where there's a long history of all these being health related. First, because Ms. Schultz acknowledged that many of the issues that she has had historically have been not health related, such as getting pulled over on the way to work, being slowed down by a train. In our exhibits, we include, for the purposes of the record, Ms. Schultz's prior disciplines and letters of expectation. In her 3-day suspension letter, or the written reprimand in lieu of a 3-day suspension letter, it is acknowledged that Ms. Schultz attributed the tardies to a medical condition that impacts your sleep and noted, here's the key phrase, that you do not need FMLA to aid you in reporting to work on time. Additionally, she stated in her mitigation that this was the 3-day was due to a train stopping. But really, as of June of 2025, she stated she did not need FMLA for that. And in the and then she had then she had the 5-day, then she had her repeated 5-day, and her repeated 5-day, according to the record here, is the one in which she was pulled over for speeding. So FMLA would, FMLA needed, first off, FMLA was not in place, and in the past she has stated FMLA was something that she didn't need for this. Now, getting into 2026, again, for two of these instances of tardiness, even if we're granting, which I do not concede, but will present for the sake of argument, even if we're granting that Ms. Schultz had FMLA in place and that FMLA would excuse the tardiness, there are at least 2 of the 4 instances in which FMLA would have nothing to do with it. In the January 16 tardy, January 16 of 2026, the second of 4, it is noted on the slip that she requested inclement weather. It was snowing 2 to 3 inches. Nobody else was tardy. So you can't have it both ways. Either you asked for it to be inclement weather, or it was due to your medical condition. Then the most recent one, there was a statement by John Ostrowski, the PCS, who filled out the work rule violation, that initially Ms. Schultz asked if she could cite inclement weather for her late arrival. Now, there we have at least 2 instances that are not health related. And again, our position is that FMLA was not in place. And if it were in place, it would not have covered this. The FMLA request was sent to the employer after this investigation had already been kicked off. It was already started, and then there was an FMLA request put in place. Now, Ms. Schultz is going to have all kinds of reasons why she couldn't have asked her doctor or didn't ask her doctor about it. The important part of that statement is that she did not ask her doctor about it. It was once she was facing down a 5th discipline, one that could lead to her termination, then it was time for her to get her doctor to approve FMLA to be retroactive to excuse her tardiness. Which, again, under the policy, requires that an employee notify their employing unit at least 90 minutes before their shift. Additionally, there is reason to believe that Ms. Schultz may not be being honest about when she asks if something needs to be a use of sick day. Within my exhibit R4, there is a letter of expectation from there's a letter of expectation from April 5th, 2023, that Ms. Schultz was issued. It was a letter of expectation, so it wasn't discipline. She was given some grace here. However, she had an absence, and this is in the letter, it's in my exhibit, on February 5th, 2023, for which she called in sick. Unfortunately, well, fortunately for her, she wasn't sick. Unfortunately for her, the wedding out of state that she attended was photographed and put on social media. So she has a history there where there have been issues of being truthful about the use of her sick time. Additionally, it seems so the then really the issue comes down to should an employee who is facing down her 5th discipline inside of a year for the same thing really be forgiven for it, because after the fact she said, oh, by the way, back then I was suffering from something which I did not cite as my reason for why I was tardy. Because it is well known among employees that if there is, that if people have an issue with their FMLA, with their leave and they're sick, and it's something that FMLA should cover, it's something that people say, well, what is your reason for being sick? You don't say, well, the inclement weather. You say, well, it's, what's your reason for being out? It's a sick day, I'm taking FMLA. She didn't request to take FMLA. She didn't request to use FMLA. If you look in the exhibits, there is one exhibit that includes some attendance, and it's an attendance tracker. And unfortunately, it was a spreadsheet, so it's over 2 pages. But if you look at it, the 1st, 3rd, 5th, and 8th lines are for her tardies. And on the right page, if you look at the 1st, 3rd, 5th, and 8th lines, they all say tardy. However, on the 4th line, there's sick leave that's listed for 2/4/2026. Not one of the days in question, where she took sick time, and it indicates that she was out at 12:30, FMLA question mark. And then there was 2 more uses of sick days, February 18, February 19, sick time listed with question marks of FMLA question mark. These were sick leave that was used, and there is some acknowledgement that this is that could be an FMLA issue. And as Ms. Steele stated, Ms. Schultz was not terminated for FMLA. She was terminated for tardiness. She was not terminated for excessive leave use. She was not terminated for using leave in an unauthorized manner. She was terminated because she was serially tardy for work. And there was no FMLA protection in place. Even if she had FMLA in place, she's still required to meet the attendance guidelines of providing notification to her employer. In her letters about her medical condition, her doctor says that that the FMLA could excuse her tardiness. It does not say that she's unable to provide a notification. Of her arrival. And in short, despite all of the efforts that Ms. Schultz and her representative are making, this is not an FMLA case. This is a discipline case. This is a discipline case, and we have shown that Ms. Schultz was tardy 4 times in 2026. She did not provide sufficient advance notice for those tardies. That violated three work rules. As Ms. Steele testified to, that is something that impacts the operation of WRC, the Wisconsin Resource Center, so it warrants discipline. There are no comparative cases here that would warrant reducing this discipline. There are no mitigating factors that would overcome this significant, really this significant, repeated, unmitigated misconduct. I hear a lot in these cases that misconduct is supposed to be corrective. Ms. Schultz had 4 chances at that. Ms. Schultz had 4 chances at that over the course of a year and failed to correct it. So at that point, the mitigating factors of I was a good employee or I had all these years of service, those don't cover it anymore. Once you have that level of repeated misconduct, therefore, this was not excessive. This followed progression. It even followed progression with an extra level of forgiveness because she had a repeat 5-day suspension. Even after that, she could not correct the behavior that led to the misconduct. Therefore, the Department of Health Services had just cause to terminate Ms. Schultz's employment. And we are today, because we have proven by a preponderance of the evidence that the department did have just cause, we're asking the commission to affirm the department's decision to terminate Ms. Schultz's employment. Thank you.
Thank you. Ms. Irwin, are you ready to proceed?
Yes, I am.
Go ahead.
Chairman Davis, what an absolute shame it is that the appellant with her serious health condition, certified by her neurologist, had to endure the stress of all the investigations and administrative leave and was terminated while the whole time Wisconsin's Family and Medical Leave Act covered employees can take leave in smaller partial day increments, such as arriving late or leaving early for their own or a family member's serious health condition. This is specifically governed by Wisconsin statute 103.106A, which explicitly allows employees to take FMLA leave in non-continuous or reduced schedule increments. This is an absolute failure of the respondent to care for their very valued and praised employee, as we have learned through testimony today. The respondent went out of their way to violate the letter and the spirit of the law, and in doing so, abandoned another hardworking employee that didn't deserve it. Chairman Davis, we are asking you today to send a message that WRC should not get away with this. It is not genuine, and no employee deserves to have their rights violated in this way. They changed the respondent changed their course when they realized they had an outright violation. These laws, these FMLA laws, were made to protect employees like Lori. This is more than a paper tiger. The respondent's legal counsel brought up a letter of expectation that was never mentioned during testimony. This shows how the respondent's legal counsel was grasping at straws. The FMLA coordinator at WRC should have been aware of the FMLA statute. Per policy, the supervisor has to inform the employee when they recognize a serious health condition. Lori never should have been put through all this stress on top of her serious health condition. As the respondent's legal counsel just went on and on about the repeated investigations, the repeat 5-day, again, written up, investigated in 2026 when she believed that her FMLA was good for a year. That, Chairman Davis, falls on Jacob Relian, the FMLA coordinator at WRC. We were not able to call him as a witness to ask him what his training was that qualified him for FMLA coordinator. How can an FMLA coordinator not be aware of an FMLA statute that would have quickly addressed Lori's serious health condition? Just listening to the respondent's legal counsel go on and on, exaggerating her discipline, the number of disciplines, the number of tardies, the investigations, the grace she was given. This was abusive on the part of the respondent. Ginger Steele sat in front of us today and completely admitted that no consideration was given to the appellant, Lori Schultz, for her serious medical condition. The DHS administrator, Ginger Steele, of all people, should be aware of the FMLA statute that clearly covers employees in smaller partial day increments. Again, Wisconsin statute 103.106A explicitly allows employees like the appellant to take this leave. The respondent's legal counsel clearly crafted his opening statement focusing on one issue and one issue only. To be frank, Chairman Davis, he completely blew it. Now he's trying to throw spaghetti at the wall to get it to stick. Chairman Davis, it is your duty to follow the law. Time and money have been wasted, further harming the appellant in this case. The legal counsel for the respondent insisted on focusing on one issue in his closing statement. Then he was going to change his tune because he got caught. And this is a typical overreach by WRC. The respondent's legal counsel has been discredited today. He's revealed that he is inconsistent. And the attorney's statements cannot be used as evidence. We were not allowed to have Jackie Dorschner as a witness who tracked WRC employees who used FMLA and called in sick. This is evidence of the respondent's malice. And on top of that, the respondent's legal counsel attempted to assassinate the appellant's character. The core theory in this case is that FMLA absences driving Ms. Schultz's termination are FMLA protected. And 29 CFR 825.22C bars counting FMLA leave under any attendance no fault system. So once those dates come out, no just cause remains. With interference and retaliation as independent violations. The respondent knows this, Chairman Davis, and it should not take a pro se former employee to rally for this clear retaliatory interference with Ms. Schultz's right to employment. It is not the duty of the respondent to determine some type of medical treatment is retroactive. The medical provider is the determining expert in this matter. Also, the respondent does not get to violate employees' rights because they are making up lost time for what they consider late progressive discipline. It is not a trade-off. We violated your rights, but you did things that we didn't like, which makes you deserving of the mistreatment and law violations. That is not how it should work. The respondent does not get a clean slate to violate the employee rights because they are later claiming that a single notification issue has now, mid-hearing, turned into a termination based on repeated absences. The respondent's opening statement fixated on the single notification issue as the only reason Ms. Schultz was terminated, and this changed into a full review of Ms. Schultz's job performance over the course of her employment. By their own admissions, the respondent did not consider the FMLA statutes of Lori Schultz at any time during her skip to termination. The decision makers and consultants did not have access to FMLA mitigating factors, nor does the respondent have clean records of call-in times, meetings, or written communications. Sources are Wisconsin Statute 230.44, Wisconsin Statute 230.34, Wisconsin Statute Chapter 227, and WERC State Civil Service Appeals. And Chairman Davis, we are requesting a recording of this hearing. And that is all.
Thank you. Any rebuttal or final comments from you, Attorney Makovic? Oh, sorry, can't hear you.
Can you hear this? Can you hear me now?
Yes.
Okay, I had to switch my audio because my headset died. Just one thing I would like to point out, 103.106A actually addresses taking family leave. That's specifically the subsections that it references are for birth or placement of children. Additionally, despite what Ms. Irwin is stating, again, this was not for taking leave. This was for tardiness, as was clearly stated multiple times. This was for tardiness, and Ms. Irwin has made no showing that FMLA protects against being tardy. It would have protected against Ms. Schultz being disciplined for having taken too much leave, for example. It's like I said, it's not a leave issue. It's not an FMLA issue. It's a tardiness issue, and that's what I want to address as just a very brief rebuttal argument. Thank you.
Anything else from you, Ms. Irwin?
Yes, Mr. Davis, Chairman Davis. Throughout the hearing, you emphasized that if the respondent violated the law, that's what this case is going to come down to. And it has been proven that they have. And again, it is so sad that neither the FMLA coordinator at WRC, nor the deputy director, Sharon Harder, nor the director of WRC, Susan DeHaan, nor the DHS administrator, Ginger Steele, nor the respondent's legal counsel, Makovic, none of these administrative professionals ever considered to look up the statute that applies. Appellant Lori Schultz never should have had to endure all of these stressful investigations with a lifelong serious medical condition that she's had since the age of 8, when she got hit in the head with a metal baseball bat. That is all.
All right. Thank you for all of that. So, Ms. Schultz, I've already made reference to the potential for you to choose to make settlement offers to the employer. One being the I'll come back, no back pay, move me to the third shift and move on. The other being less desirable, let me resign, which the little I know about it probably opens up the ability to think about retirement benefits, et cetera, which you may not have access to now under the current circumstance. So just be realistic about it. There is a potential that you will lose this case. And if you lose it, that's it. I mean, obviously, Attorney Irwin can take it to court. Excuse me, not attorney. Your representative, well, she can't take it to court. You can take it to court. You'd have to hire a lawyer, do it yourself. So I just want you to be realistic about the potential for you to lose this case, despite your arguments from your employer. She may not be correct. And if she is incorrect, you will lose the case. So to the extent there are options out there that do not give you exactly what you'd like, but are better than losing the case, I encourage you to seriously think about those and potentially, totally up to you, make those offers, either one or both, to the employer. They may say no to both, and then you won't have any choices to make. But it's possible they might say yes to one of them or both of them. And, part of the WRC's business is resolving disputes. So I just want to put that out there for you to give serious consideration to. If it settles, there's nothing shows up on the WRC website, and life goes on for everybody. So encourage you to think about that. You don't need to comment about it. You don't make any commitments that you'll do it. I just wanted to reemphasize that potential. So with that, I think we're done. I will put in an order for the hearing transcript per Ms. Irwin's request. Attorney Makovic, do you want a copy of the recording?
No.
All right, very good. So I'll obviously want a chance to mull this over, listen to the recording myself before I make any final decisions. I think we have a little bit of time left in terms of my 120-day obligation, but it is a discharge, so I'll try to get to it as promptly as I can. I do want to give at least a couple weeks to play, and I won't be getting to this the next couple weeks in terms of any settlement possibilities to play out one way or the other. So I wouldn't anticipate a decision until, I would say, early August would be a realistic time frame. If it happens to settle between now and then, great. If it doesn't, I'll be issuing a decision. So anything else from anybody before we adjourn?
I would just like to thank you on what you had just said.
Well, my pleasure to point that out. I will revisit the concern that you expressed before your case started in terms of my reaction to the meeting and did the meeting occur, et cetera, et cetera. One of the downsides potentially of being able to see witnesses. My recollection, which could be incorrect, is when the employer witness was testifying that the meeting occurred, my recollection is that you were shaking your head no. And when I saw that, that's what in effect prompted me to throw that out there, that I don't know if it did or didn't, but it's a difficult, dangerous place to go as to whether a meeting did or didn't exist. That was why I did what I did. I think I explained earlier on, I was misconstruing your reaction. I think you were misconstruing my question. And I hope we're all square on that, but I just wanted to revisit that for whatever it's worth.
I appreciate that.
You're welcome. All right. If nothing further, I think we are done for the day. I will hope against hope that I don't have to write a decision in this matter. But if I do, I'd anticipate early August as being the time frame when a decision would be issued. Thank you, everybody. I think we're done.
Thank you.
Thank you.
Take
Thank
care.
you.
All right.